have received the mail. File is there related. Lunch time. I need it. I've gone through it thrice. ज़्यादा कुछ है नहीं करने के लिए. Go through.
From supplementary list.
First appeal 126 of 2019 was disposed of on 23rd of June, but till date the order has not been.
I know it is under correction. It is under correction. It takes time for correction. हर एक चीज टैली करना पड़ता है सर. रिकॉर्ड बहुत ज़्यादा टैली करना पड़ता है.
No, I was told that in a few days it will come. It will come.
It will come. It will take time. और आप अपना सर्टिफाइड कॉपी के लिए तो अप्लाई कर ही दिए होंगे, तो आपको सर्टिफाइड कॉपी मिलेगी. लेकिन जब तक हम हर एक फैक्ट को टैली नहीं कर लेते, कोई भी जजमेंट लिखाते हैं ऑन द बेसिस ऑफ द डिक्टेशन जो आप लोग सबमिशन करते हैं, लेकिन हमको सारा फैक्ट्स रिकॉर्ड से टैली करना है. वो हम लोग ज़रूर करते हैं. एट द टाइम ऑफ डिक्टेशन इट इज़ नॉट पॉसिबल एंड वी ट्रस्ट यू दैट ऑल द आर्गूमेंट्स आर करेक्टली मेड, लेकिन हम लोग को वो सब टैली करते हैं. ठीक है, इट विल बी लो अपलोडेड. चिंता नहीं करिए सर.
From supplementary list for final source item 2, first appeal 136 of 2024.
Not sure to recall this matter actually. One of the plaintiff had died lordship in the trial and he was not substituted. Now, only on the point of whether lordship this case will be heard by this court or will be remanded back. Two judgments lordship I have cited. Now one more judgment lordship I have just from the Indian bench. Recently lordship by this honorable court.
Which all judgments you have cited?
That is their lordship in
the last order it was recorded.
Yes.
There are 3 judgments which were recorded. One is
2005 lordship.
2016.
Yes.
One SCC 607. The other is 2005 volume 6
There are
SCC
6 and 9 lordship is
300. Yes, it is.
One was
Other
CMP.
is CMP number
By the coordinate bench of the
928 of 2022.
Although lordship is a division.
And there is one more judgment of Honorable Supreme Court.
Yes.
That is civil appeal number 13407 of 2024. This is judgment dated 11th of February 2024.
No,
Correct?
this is very recent judgment lordship. I was also appearing in this case. Although lordship is a revenue matter, but the same principle was applied of 2016 SSC. 2016.
LPA number 457 of 2020.
In this case,
Who is
lordship,
there for the private respondent? Newly added respondent की तरफ से कौन है इसमें?
they have appeared.
Where are they? You see, the point is that those persons who were not substituted, they are not aggrieved.
No, lordship, what have submitted.
They are not aggrieved, correct?
They were the heirs lordship of a
Maybe,
deceased person.
but they are not aggrieved.
That can be a point lordship, arguable point lordship. I am only on
So
the
therefore you argue everything.
judgment and degree lordship.
We will see that.
Lordship, only one thing I am submitting.
You argue on merit.
Yes,
as well.
I'll be adding lordship. Only one thing I am submitting lordship. आज जो lordship is knowing, I trust हुजूर आपकी का I'm on my own constraint lordship. इसको next Tuesday को as it is रख दिया जाए हुजूर. I'll argue on merit and only one thing lordship I'll be submitting. Since lordship the decree is already there and the decree can be amended by the trial court itself. I'll argue on merit.
आप एकदम चिंता मत करिए. आप ये वाला जजमेंट देखे हैं? सिविल अपील नंबर 13407 of 2024.
I'm just I think I had some right. One thing lordship.
ऐसा लग नहीं रहा है कि आपने
एक मिनट बताएं.
सिविल अपील नंबर 13407 of 2024. Decided on 11th of February 2025.
I'll also see this. If I had not.
You need to see this judgment.
एक मिनट देख लेते हैं. Yes, lordship. I had some right. I have this.
Maybe you have placed it. It's good that it is there on
This is
record.
a reportable.
This is there is one passage in this. नहीं, एक ये वाला जजमेंट हाँ ये वाला, ये CMP 9/28 of
9/28.
22
That I had.
हाँ that you have referred. इसका जरा ये वाला पैराग्राफ पढ़िए, पैराग्राफ 10. Para 10 point. It is absolutely the discretion of the legal representative whether they want to challenge it or they do not want to challenge it. आप उनके सगे भाई हैं, आप उनके सगे रिलेशन हैं, right? You did not take any steps for substitution.
That is my fault.
Right? Your fault.
Yes.
So you will have a premium on your fault.
No, not at all.
They are not aggrieved. You just see. They are not aggrieved. They have not filed any appeal before this court.
I'm just only.
You आप पैरा 10 पढ़िए ना.
हम उसको देखें, हम उस पॉइंट पे नहीं हैं, हम इसी पॉइंट पे हैं कि I'm not trying to get any premium. Lordship, I'll be arguing this case on merit.
बस मेरिट पे बहस करिए भाई.
Next Tuesday, खाली as it is on
ये
court
सब
में.
ठीक नहीं है ना.
नहीं, नहीं,
कॉम्पनसेशन का मामला
नहीं,
है,
नहीं.
रिमांड करके क्या हासिल
The
होने वाला
impression
है,
should
क्या
not
होने
go.
वाला है.
Impression should not go that I am seeking any
This is not a
premium.
matter of
Only
impression.
Lordship,
You see,
only Lordship.
आपको एक चीज पता है.
The procedural
I'll tell you
aspect
one
has to be
thing.
rectified. That
Why
only for
am I
that
so
purpose.
vocal in the court? I am so vocal in the
Yes,
court.
yes.
Such that you know that what is going on in my mind.
Yes, yes.
ऐसा साइलेंटली एक ऑर्डर कर देने
नहीं,
से
नहीं.
क्या फायदा है बताइए.
Therefore, I said, Lordship, only the procedural.
इस तरह से साइलेंटली ऑर्डर करना इज नॉट प्रॉपर कि सुने एक ऑर्डर कर दिया और
नहीं,
उसके बाद
नहीं.
उसको चैलेंज करते रहिए.
बिल्कुल.
हमको ऐसा
बिल्कुल
को नहीं पसंद.
नहीं कोई बात नहीं. हम हुजूर इस पॉइंट पे ही आर्गुमेंट कर देंगे और मेरिट पे.
आप मेरी ठीक है, ठीक है. कब करें?
नेक्स्ट ट्यूसडे या उसके 2-4 दिन प्रोसेस में टाइम लग रहा है. माय पर्सनल डिफिकल्टी, हम अपनी बात कर रहे हैं.
रिकॉर्ड का सॉफ्ट कॉपी आप लोग ले लीजिए, कल को रिकॉर्ड मत मांगिएगा. प्राइवेट रिस्पोंडेंट की तरफ से कौन है जो अपीयर हुए हैं इसमें?
I'll inform.
ही इज एब्सेंटिंग. उनको कोई लेना देना नहीं है. नोटिस मिला है, सिर्फ अपीयर हो गए. कल भी नहीं आए थे वो, आज भी नहीं आए हैं वो. राइट? They are not here. They are not bothered. They are happy with whatever has happened.
That they will reply. I'll argue on merit. So after 5-10 days, जब भी हुजूर एक डेट दे दीजिए, I'll not
FA
be
number
seeking.
136 of 2024. Learned counsel for the appellant seeks adjournment by way of last indulgence.
हुजूर 28 को रख दीजिए, 28 तारीख.
The matter is directed to be posted on
So on Monday also the matter will be continued.
28th of July.
Lordship.
It is made clear that no
No, sir.
adjournment will be granted. मांगेंगे adjournment?
नहीं हम नहीं लेंगे.
1 लाख रुपए cost.
हम नहीं लेंगे हुजूर. फीस नहीं देगा तो छोड़ देगा केस. नहीं
हम आज पूरा पढ़ के आए थे.
नहीं हम भी पढ़े हैं हुजूर. I know what is the merit in my case. I very much know. But only for the procedural should
क्या
not be
होता है
there.
कि
Yes.
कोई भी रिकॉर्ड फर्स्ट केस है, अगर हम उसको पढ़ रहे हैं तो आई स्पेंड हाफ एन
I know,
आवर
I
मिनिमम
know.
टाइम
I know.
एंड दिस टाइम इज स्पेंट एट द कॉस्ट ऑफ अदर केसेस.
कल लास्ट में हुजूर कॉल हुआ. अगर हम रहते तो कल ही हम बोलते थे कि आज मत रखिए.
चलिए कोई बात
ठीक.
नहीं, आप तो ऐसे टाइम नहीं लेते हैं. एंड इट विल ऑलवेज बी अ प्लेजर टू हियर दिस टेक्निकल पॉइंट.
Lordship.
आप लोग सॉफ्ट कॉपी ले लेंगे रिकॉर्ड का, आप लोग को चाहिए तो. वो जो प्राइवेट रिस्पोंडेंट है जिनको नोटिस हुआ था, कौन था रिस्पोंडेंट नंबर 7 and 8? ऐड जिसको किए थे
हाँ,
हम.
सर.
7 आप हैं?
नवल किशोर पांडे.
अच्छा, 7 and 8 की तरफ से नोबडी appears लिखा है.
Order to defect item 3, first appeal file number 3378 of 2025.
Yes, madam. How much time do you need to remove the defects?
Item I for ignoring the
Which defect?
There is a defect that respondent number 30, defendant number 30 in the suit has not been made party here, and defendant number 40 in the suit has been made party who was not party in the lower court. Defendant number 3, your lordship, has been substituted in the lower court. That has not been added in the certified copy of the order, your lordship. We have also placed on record the order by which the substitution was
Then the
done.
certified copy has to be sent to the court concerned for rectification.
Your Lordship, but we've already placed the order by which the substitution was made.
No,
Your
no,
Lordship.
that the decree, everything has to be modified, no?
The decree is
Decree
not-
has to be amended, then the judgment it has to be taken care in the judgment. The order has to go to the court concerned. Who was substituted defendant number?
13, Your Lordship.
There is no defendant number 13.
Defendant number 13 in the title suit, Your Lordship.
Yes, title suit only. I'm looking at the title suit. There are only 12 defendants.
Page number 58, Your Lordship.
Page number 58.
Last para, Your Lordship, 13
Oh,
Dr. Bharat.
later on, yes. There is one. Okay, she was substituted.
Yes, Your Lordship. He was substituted, Your Lordship.
Okay, he was substituted. So the judgment and the decree is required to be rectified to that effect. And what else is there?
Your Lordship, defendant number 13, Your Lordship, she had 5 children. 3 are already party. One of them has died. So the 5th one has been made party in this appeal, Your Lordship. That is
Which
one
did
more
care?
defect.
When did she die? After the judgment?
No, Your Lordship, during the 4th child, Your Lordship, during the pendency of the suit, Your Lordship, she was also substituted, Your Lordship.
Sorry, what's her name? Who was
Geeta
substituted?
Devi.
Geeta Devi.
She is not made party in the title suit, Your Lordship.
She has not been shown as a party.
Yes, Your Lordship, that is the problem, Your Lordship. He has not been substituted with his heirs in the certified copy that we have, Your Lordship.
So only the rectification in connection with the heirs of defendant number 13 will suffice?
Yes, Your Lordship.
देखिए FA number 3378 of 2025. The learned counsel for the appellant has submitted that defendant number 13 was substituted in the title suit, but the substitution has not been carried out, has not been incorporated in the impugned judgment. You are filing, why it's such a short judgment? Yes. What is it?
It's 10 paragraph judgment.
Review was allowed.
Yes, Your Lordship.
Review was allowed.
Yes, Your Lordship.
So you will not challenge the main judgment. Where is it? Neither it has been annexed. What kind of appeal is this? The plaint has been rejected. Where is the impugned order rejecting the plaint? You have challenged the order rejecting the plaint.
Yes, Your Lordship. 6 February 2025 judgment we have challenged, Your Lordship. That is the review, the judgment with the review, Your Lordship.
In the review, the plaint has been rejected.
Yes, Your Lordship. It's review of the order of the rejection of the plaint order, Your Lordship.
And the suit is held to be barred by law as provisions of Section 4. You see, you filed a review petition.
Yes, ma'am.
There has to be one more order.
The rejection order.
Yes,
Your
where is
Lordship.
that?
That order is not.
ज़्यादा काम आ गया ऑफिस में.
No, Your Lordship, that is not been annexed, Your Lordship.
ज़रूरत से ज़्यादा काम आ गया.
Been annexed,
What has is this?
Original order, Your Lordship.
The counsel for the appellant has submitted that the impugned order passed in this case is dated 6/2/2025, passed in civil within bracket review bracket close miscellaneous case number 1 of 2025, whereby the review has been allowed and the plaint has been rejected under Order 7 Rule 11 within bracket D of CPC, by holding that the suit was barred under Section 4 of Benami Transaction Act. The impugned order reveals that the order under review was dated 3/10/2024, whereby petition under Order 7 Rule 11 with the bracket D, read with Section 151 CPC, was filed by defendant number 2 and 3 was dismissed. But the said order has not been annexed. Counsel for the appellant undertakes to file a copy of the order dated 3/10/2024, passed by the learned court. Further, the learned counsel has submitted that the defendant number 13 had expired during the pendency of the suit,
Yes, Your Lordship.
and was also substituted, but the impugned order has not carried out the substitution.
And also, Your Lordship, further revision of one of the legal errors of this.
She has also submitted that one of the legal years of respondent number 13, defendant number 13, had also expired during the pendency of the suit and was deleted, but those things have not been incorporated in the impugned judgment, due to which she is unable to carry out the she is unable to remove the defects. Office is directed to send back the impugned order to the concerned court for rectification, along with a copy of this order. After rectification of the order, the same be sent back to the court, along with the records of the case. We need to see क्या किए हैं, review में क्या था, क्या नहीं.
Will also annex
And
the
this will,
original order.
I do not know, आपको जो मर्जी करें. और Order 7 Rule 11 में जब claim dismiss होता है, right? Then the appeal would lie.
Your Lordship,
The first
against
appeal would
review-
lie.
Against the review, Your
We
Lordship.
do not know, even against the review. No decree is drawn. The first appeal would lie.
Yes, Your Lordship.
Yes, no, ऐसा मत बोलिए. समझिए. नहीं लगता है कि ऑर्डर 7 रूल 11 में जब क्लेम डिसमिस होता है तो
We looked into there is a judgment regarding this, then we'll get the judgment on the next.
आई थिंक सिविल डिविजन लाइक
We'll check and get the judgment.
यहाँ तो सिविल के दिग्गज लोग दिख ही नहीं रहे उन्हीं सब उसने पोस्ट ऑन 1st of September.
Item 4, first appeal file number 698 of 2025.
What is it?
Because it has come with the defects, the defects say, but the court fee just now we have yours deposited. So the rest of the defects are minor notes, that in the course of day we will remove all the defects.
Learned counsel for the appellant.
The only notes my suggestion is I filed one interrogatory application also
For what?
for nurses stay of this.
डिफेक्टिव पिटीशन में स्टे ऑर्डर नहीं हो सकता है, ये हमको आपको समझाने की जरूरत
Nurse
है।
have status to because they have started.
वो तो
Nurse,
आप-
my submission is nurse.
देखिए आपने 1/7/2025 को फाइल किया है, द पिटीशन इज डिफेक्टिव। डिफेक्टिव पिटीशन में हम कुछ भी इंटरमीडिएट नहीं करेंगे। FA नंबर 6928 of 2025, counsel for the appellant submits that there are only minor defects to be removed and the court case has already been filed.
Today nurse.
Is being filed today.
No, I have filed.
And the deficit court
Deficit.
case has already been filed. He prays for and is granted कितना टाइम चाहिए आपको?
Nurse, the defects I will remove by tomorrow.
He prays for and is granted time till (23rd of July) to remove the surviving defects. The learned counsel has also submitted that the matter arises out of specific performance of contract.
No, nurse, it is for nurse declaration of two nurse sale deed to be illegal. Nurse and for additional nurse declaration of my right, title and possession over the land which I have purchased in 2011. So the court has finally nurse come to a conclusion that whatever land which I have purchased, total land purchase was 75 decibel. The court says out of 75 decibel, only 35 decibel is admissible to you, and then directed not the person who has transferred this land to me by a valid sale deed, Lord, he should pay back the entire money to me along with the interest. for the rest of the land.
In
Out
your
of
interlocutory application, you have not mentioned the execution case also.
execution case has not yet
Is not mentioned.
it has not been filed. Only they have started the construction over there because the direction of the court below is very specific. So once they will change the nature of landowners, that will create a problems. Any date it shoots to my lord.
Pose this case on 28th of July under application.
Because the only issue is not that by only 1 minute.
देखिए अगर आपका ये डिफेक्ट फ्री होता ना तो 15 दिन में डिसाइड कर देते, लेकिन आप चाहते ही नहीं.
डिफेक्ट फ्री आज कोर्ट फिर फाइल आप आज कर देते हैं. आज टुडे आई विल
रिकॉर्ड कॉल फॉर आपके कॉस्ट पे करते, एग्जीक्यूशन चल रहा होता तो एग्जीक्यूशन कोर्ट में सर्विस कराते और 15 दिन के अंदर इस केस को लिस्ट कर देते.
एग्जीक्यूशन नहीं
लेकिन
एग्जीक्यूशन
डिफेक्टिव पिटिशंस में आएगा.
डिफेक्टिव एक्चुअली क्या है ना, उन लोग की इसमें डिग्री बना, डिग्री हम लोग को 2-3 रोज पहले मिला, डिग्री हम लोग फाइल किए.
कोई बात नहीं. नहीं करिए है तो काउंसिल है.
Item 5 CMP 1064 of 2024.
आप हैं अदर साइड से.
As per the office report, 3 of the performer respondent has died. Recently, I am going to the report.
तो फिर आपको सब्स्टिट्यूशन फाइल करना होगा. और कुछ डिफेक्ट है आपका.
The limitation is there also for 730 days. For that purpose, I have already been filed. So
Okay.
that also been.
How much time चाहिए? कितना टाइम चाहिए आपको?
So if it for the for substitution, filing the substitution, उसके बाद हम लोग अपडेट करते हैं.
कितना टाइम चाहिए?
I need 1 week time only.
1 week. CMP number 1064 of 2024. The learned counsel for the appellant submits that respondent number,
Performer respondent number 3, 4, and 5.
pro forma respondent number 3, 4 and 5 have expired and he prays for 1 week time to take appropriate steps. Post this case on 29th of July in the supplementary cause list. आप आ जाएंगे और बॉर्डर्स में रहेगा जो भी, ये सब तो कवर्ड केसेस होंगे मेरे ख्याल से.
कैसे रहता है जरूर आते
हाँ
हैं
आप जरूर आते हैं.
इसलिए कि एक बार आप कोर्ट में ओपनली कर दिए उसमें
हाँ जब एक बार देखिए कोई एक चीज कंटेस्ट होकर डिसाइड हो गया तो फिर वो सारे मैटर्स एक साथ फिर हो ही जाने चाहिए ना.
इसीलिए हम हमेशा हर छोटा मोटा मैटर होता ही है.
नहीं आप हमेशा ही रहे. There is no doubt.
For admission item
आपकी
6 first
सिंसियरिटी
appeal.
में हम लोग को डाउट थोड़ी है.
Item 6 first appeal 98 of 2017.
The matter has already been decided. And
कौन सा जजमेंट से?
by Kadru is a coding matter. It's 82 of the first appeal 82 of 2017.
आप लाए रिकॉर्ड भी है यहाँ. उसका रिकॉर्ड जो एलसीआर आया था. एलसीआर नहीं हुआ ना साथ में. कोई बात देखिए ना एलसीआर हम मंगा के लेकिन फॉर्मली तो एडमिट करना होगा ना.
यस
ठीक है. FA number 98 of 2017. The learned counsel for the parties are present. They submit that the case is squarely covered by the judgment rendered by this court in first appeal number 82 of 2017, which has already been decided
On 4/4/2021.
on 4/4/2025,
Along with 84, 85, 86, 87.
along with analogous cases. However, they submit that the case be formally admitted and decided. Admit. Post for final disposal tomorrow. along with the records of
82 and 84.
first appeal number
82 of 2017.
82 of 2017. ठीक है? उसमें ऑफिस नोट में लिखा हुआ होगा रिकॉर्ड्स आया है.
लिखा हुआ है कि
अब कोई बात नहीं, मंगा के ना कल इसको लगा दीजिए, कल इसको डिस्पोजल करेंगे. और वो जो जजमेंट है वो जजमेंट की कॉपी.
for hearing item 7, first appeal 176 of 2023.
So this matter has been compromised. Lordship, may kindly see the last order.
Yes,
The
yes.
respondent was
Absolutely.
supposed.
Who is coming?
So the supplementary affidavit has been
I've
filed
seen-
by them. It is on record.
I've seen that. So it can be disposed of in terms
Disposed
of
of, yes,
compromise. Let him come. It will be taken up at 12 o'clock.
For special medicine practices, item 8, second appeal 34 of 2018.
This case is similar matter to
Like- Similar.
similar.
Similar means same party,
Same party.
same suit premises.
Milord, different suit premises, there are many cases, eviction
So how
suit.
does that mean? एक केस हम नॉट बिफोर मी कर दी, इसका क्या मतलब है?
एक्चुअली इसमें मिस्टर धर्मेंद्र मल्टियार है रिस्पोंडेंट साइड से आउट ऑफ स्टेशन है, तो बोले कि ये सिमिलर मैटर है इसलिए इसको
सिमिलर एक लिटिगेंट का 10 सिमिलर मैटर हो सकता है.
Milord, there was another matter in which there is a decision of my lord in this matter.
दिखाई.
And it has been decided in favor of the appellate company. There it was we were the respondent. There are various suit premises will not occupy.
ये वाला तो अपहोल्ड भी हो गया सुप्रीम कोर्ट.
Yes, Milord,
This
and
has been upheld by the Supreme Court. I am aware of it
yes, maybe Milord.
because there was a communication from the
Yes.
Supreme Court regarding this. I remember बहुत लड़ाई हुआ था.
And this is the same and similar matter.
कोई बात नहीं, मीडिएशन के लिए आया है. We are not bothered about this. मीडिएशन के लिए भेजना है तो बोलिए भेज देते हैं.
Milord, mediation में eviction suit is there, Milord, which was decided order of reversal है. Now, if they are ready to evict the suit premises on the terms and conditions, we can mediate it. We can mediate.
We will just send it for mediation. Whatever is decided will get decided. इसमें क्या है?
Wait, terms and conditions, they have to agree for
Whatever.
Yes.
See, mediation में we do not circumscribe the litigants की किस terms में mediation. Right?
I am asking him if they are ready to mediate, otherwise it will be a futile exercise. If they are ready to evict the portal and thereupon on the terms and conditions we are ready to mediate. Otherwise it will be sent there and the matter.
मीडिएशन में भेज दें. इसका रिक्यूजल से क्या लेना देना है? मीडिएशन में भेज देते हैं आपको. ठीक है? With the consent of the learned counsel for the parties, let this matter be placed before the वो mediation वाला order. देख लीजिए, वो सेटल कर लीजिए. कुछ पैसा का लेन देन हो, खाली करने के लिए कोई टर्म्स एंड कंडीशंस हो तो अपने डिसाइड करके कर लीजिए. ये एग्जीक्यूट हो गया.
Milord, in all likelihood हो गया है. और ये वाला
हमको याद है कितना दिन तक इसके से अच्छा वो जजमेंट हमको दे दिए, क्योंकि हम एक दिन खोज रहे थे, इसमें कुछ डिसाइड किए थे. इसमें एक चीज़ डिसाइड किए थे, मार्किंग ऑफ प्रूफ ऑफ सर्टेन डॉक्यूमेंट एंड मार्किंग ऑफ सर्टेन डॉक्यूमेंट में क्या डिस्टिंक्शन है. आई थिंक इसमें हम डिसाइड किए थे, हमको याद है कुछ तो ऐसा किए थे इसमें. There is a distinction between marking of document and proof of document. किसी कारण से हम इसको कर दिए होंगे. I don't remember क्यों कौन सा केस को रिक्यूजल किया है मुझे. I just because for Tata Steel I was never a counsel in civil matters. I was doing only taxation. तो इसीलिए civil matters में मेरा कोई such I have nothing to say in civil matters.
इसमें सिर्फ और सिर्फ क्वार्टर नंबर का डिफरेंस है एंड बिकॉज मेनी केसेस वेयर देयर इन बिटवीन बोथ द पार्टीज दे वर होल्डिंग मेनी
Every case has to be decided on the basis of evidences placed on it.
यस
ऐसे ना writ की तरह नहीं बोल सकते. Similar matter, first appeal,
ये
second
तो है
appeal.
भी नहीं बिकॉज पार्टीज भी अलग हैं ये जो इनके पास है
ठीक है ना, इसको
ठीक
मीडिएशन में भेज दे रहे हैं.
ओके
उसके बाद जब अगली बार आएगा, क्योंकि आपने ऐसा रिक्वेस्ट किया रिक्यूजल के लिए, हम रिक्यूजल कर भी देंगे. लेकिन मीडिएशन में जाने में तो कोई हर्जा नहीं. अननेसेसरी, यू नो, वी डू नॉट वांट एनी काइंड ऑफ क्लाउड इन द माइंड ऑफ एनीबॉडी. क्या जरूरत है? ठीक है, देयर आर सो मेनी बेंचेस टू डिसाइड केसेस.
From date list for final disclosure item 1, first appeal 46 of 2023.
Lordship, seeking an adjournment for 10 days.
What is the reason for adjournment?
Actually, we filed inspection for going through the LCR, but in the meanwhile, we could see the LCR, the record was written.
अच्छा, इनको जो है ना, पेन ड्राइव है आपके पास, इनको पूरा रिकॉर्ड दे दीजिए. रिकॉर्ड इनको इंस्पेक्शन के लिए नहीं मिले. ये सब कोई रीजन नहीं है. ओके, यहाँ पे सारा रिकॉर्ड, यहाँ पे स्लिप देके सारा रिकॉर्ड आ जाता है और आपके सारा चीज़ का सॉफ्ट कॉपी अवेलेबल है. यू जस्ट टेक इट इन द पेन.
Senior will argue.
हाँ, दैट टाइम. एडजर्नमेंट के लिए ऐसे बहाने मत बनाया करें.
No, Lordship, yesterday we filed.
By way of last indulgence, right? You have not filed any reply.
We filed.
Have you filed or you have not filed?
No, Lordship.
Right to file reply is closed. Correct? FA number 46 of 2023. By virtue of order dated 7/6/2025, the respondents were granted 3 weeks' time by way of last indulgence to file a response to the interlocutory applications to produce additional evidence being IA number 4333 of 2025. Earlier time was granted by the order dated 8/4/2025 and the reply was to be filed latest by 11/7/2025. Admittedly, the reply has not been filed. Therefore, right to file reply to interlocutory application being IA number 4333 of 2025 is closed. Counsel for the respondent, praise for time.
Lordship will file within.
ले हो गया ना खत्म. So what? There is no prayer for extension. चलिए. कब रख दे बताइए. कब तक आपको मौका मिल जाएगा सब कुछ पढ़ने का. इनको दे दीजिए सॉफ्ट कॉपी. अभी लेके आइए पेन ड्राइव. दोनों को दे दीजिए. Post on रिकॉर्ड आ गया इसमें ना सारा कुछ. बताइए कौन सा शुभ दिन निकाले हैं आप लोग.
Need it within 10 days.
10 days. काउंट करिए 10 days आज से. Post on 28th of July. Counsel for the respondent has undertaken that on the next date he shall not seek adjournment. Done?
Item 2, first appeal 118 of 2023. Yeah, tell me.
This is now proceeding ex parte. Also proceeded ex parte before the learned trial court. The issue was pleased to grant them one more indulgence and also
You argue they are not appearing. You don't need to bother about it. You argue your case.
I filed my written notes of arguments as well as
First appeal written notes of arguments in the hoता है. आपने फाइल किया है. It's good that you have filed it.
the litigation would ask me.
Now, I know. But first appeal is to be argued right from the plaint.
Yes.
It was ex parte before the trial court.
Yes. Arising out of a partition, we need to premise what the case is. This is not a case of ancestral property. This is a case of joint purchase. Total of 9 katthas.
Just a moment. Let's just have a look at it. The suit was decreed
No, it was dismissed.
Oh, the suit was dismissed and you are the plaintiff.
Yes.
Let us see the plaint. Place the plaint, please.
From the first paragraph.
Yes, of course.
That the landed
Hmm.
that the landed property situated in Mauza, Dhanbad, Mauza number 51 appertains to Khata number 61 and 80 bears plot numbers 1030, 1034, 1035, 1036.
First, let me check regarding completion of service of notice.
Yes. It was served, I think, to the wife or some family member.
Okay. There is only one respondent.
Yes.
Yes.
That the landed property situated in Mauza, Dhanbad, Mauza number 51 appertains to Khata number 61 and 80. Bears plot numbers 1030, 1034, 1035, 1036 and 1037 measuring area 15.42 decimals, or to say 9 kathas, 5.5 chata, consisting of 4 rooms lawfully and in detail described in Schedule A of the plaint purchased by the plaintiff and defendant by registered sale deed number 6594 dated 9/5/2011, followed with the deed of rectification number 9418 dated 1/7/2011 and entered in peaceful joint possession thereof. It would not be out of place to mention here that out of total purchased area, that is 15.42 decimal, or to say 9 kathas, 5.5 chata, plaintiff has purchased measuring area 7 kathas and defendant has purchased measuring area 2 kathas, 5.5 chata, as it would be evident from registered sale deed number 6594 dated 9/5/2011 itself.
And the deed was rectified.
Yes. It was
What was the rectification
It
about?
was instead of 80, it was 86. So that rectification was given.
That plot number.
Plot number. It was incorrectly, in fact.
Area, there was no rectification
No.
regarding area.
No rectification.
Mutation, joint name.
Yes.
Okay. Then jointly got the repair, construction, etc.
Yes.
Then what was the compromise decree?
That was not brought on record.
Not brought on record.
Not brought on.
Okay, so you are not concerned with the compromise.
It is my case because they had not appeared, they had not disputed. The learned court had
No, no.
called for records.
No, no. But compromise has to be proved.
It ought to have been proved.
It has to be proved. When you are talking about a compromise decree, even if they did not appear and they do not file a written statement, the compromise has to be proved.
Compromise was not with them. Compromise was.
Maybe with anybody.
The
If you are
vendor-
relying upon that compromise and if it has a material bearing in the matter, then compromise has to be.
That is the most fatal part in my case. But there are other issues that I would like to.
You see, how is this compromise related? Read paragraph.
That it is pertinent to mention here that previously Rameshwar Roy Gwala alias Rameshwar Yadav and others got the Schedule A land by virtue of compromise decree passed in Title Suit 6 of 1966, and accordingly they continued in peaceful possession thereof by exercising diverse acts of ownership in possession by construction of structures over the portion of the same. Paraphrasing. That Sri Sabhapati Yadav and others being legal heirs of and successors of Rameshwar Rao Gwala, alias Rameshwar Yadav and others, sold and transferred the same to the plaintiff and the defendant while registered sale deed number 6594 dated 9/5/11, followed by rectification deed number 9418 dated 1/7/11 through their constituted power of attorney, namely Shri Vijay Shankar Prasad, who was examined as PW1, by general power of attorney number Roman 4-256, and put the vendees in peaceful possession thereof. That it would be not be out of place to mention here that one Virendra Kumar Bhatia filed title suit number 139 of 2012 against the plaintiffs and others, claiming portion of Schedule A land, which has been dismissed by judgment and decree dated 17/6/2015, passed by Sri such and such Civil Judge Senior Division 7th at Dhanbad, against which Virendra Kumar Bhatia preferred title appeal number 83 of 2015 before the learned Principal District Judge Dhanbad, subsequently transferred to the learned Court of District Judge 4 at Dhanbad and the learned District Judge 4 at Dhanbad after hearing the parties and considering all material evidence oral and documentary available in the record, pleased to dismiss the appeal by judgment and decree dated 27/6/2016. I just want to point out that both of these judgments are brought on it. Both the suit
Any
and-
second appeal?
No second.
Are you sure?
Yes, no second appeal. Because there was a concession made by the plaintiff there. I was not the plaintiff in the title suit. The plaintiff went in title appeal and he conceded that he is not claiming my property. That I can demonstrate for you.
Then-
Another thing I want to point out, since we are on para 5, is that the general power of attorney was subsequently called for earlier at first instance was not reduced by me. Thereafter, by way of invoking 165 of the Union Evidence Act, the learned court directed me to produce it. So I produced it, and they were subsequently marked. There are two general power of attorneys. They were subsequently marked as Roman 1 and Roman 2. And the learned court,
General power of attorney, where is the reference of that general power?
that is in para 5.
Para 5. Para 5, right? Okay, this is general power of attorney. This was marked exhibit.
There are two general power of attorneys.
There is one general power of
in the
attorney, number
plate.
4.
In the plate.
Yes.
Thereafter, I was directed to file my general power of attorneys. That is
GPA, this was marked as exhibit.
1 and 2.
Where is the reference of second and general power of attorney?
Yes. It is in the impugned judgment.
No, it must be there in the plaint also.
It is not there. Because I think both are numbered 1 is 4 of 256 and 1 is 4 of 361. Only 4 of 256 is referred to in the plate.
And 4 of 361,
Is not referred.
this was marked as,
Exhibit 2, Roman 2.
this is exhibit 2 and this one
4 of 256 is exhibit 1.
4 of 256 is exhibit Roman 1.
Yes.
All these, both these were in exercise of power under section 165.
Yes. That is explicitly there in the impugned judgment. That upon invocation of 165.
Then
Subsequently, the learned court also in exercise of section 33 read with 165 suo moto called for records of title suit 139 of 2012 in which I was not the plaintiff and read documents that were adduced by the plaintiff in that case. Those have been marked subsequently as Roman 3, 4 onwards, 3, 3 by 1, 4, 4 by 1, etc. So my argument
by
here-
which order? Order dated?
Yes, 25/4/2023.
So this initial power under section 165 was exercised on which date?
That leadership I was unable to ascertain, but I know that the subsequent invocation under 33
What prevented you from ascertaining it?
it was unclear to me as to when this was called for when I went through the records. But I know it was called for and we had reduced.
You know means what? I have to write it in the judgment? No. Should I also say that the council knows and therefore I know?
The exact date on which the two general power of attorneys were reduced, that I am not aware of right now. But the dates on which the learned court called for the title suit records, that I know. That is in para 4 of my written notes also, that I have filed.
Half baked facts से कैसे हम लोग decide करेंगे?
बस वही एक चीज उसके लिए I had asked also, but
Ask what?
for the records.
Who refused you?
No one refused, but
हम अभी उसको पनिश करेंगे जिसने भी आपको रिकॉर्ड का एक्सेस रिफ्यूज किया.
no one refused.
I'll initiate a disciplinary procedure. Tell me who refused access to you.
No one refused.
Then?
But I was unable to, at the appropriate time, I was unable to go through that part of the records.
यहाँ पे ना रिकॉर्ड्स के लिए ना बहाना मत बनाया करो. हमको बिल्कुल पसंद नहीं. यही जो है इसे. ये अच्छा नहीं. बस यही है. Is there any reference to title suit number 139 of 2012 in your claim?
Yes.
There is a reference.
Yes. It is at para 6 of my claim.
Is there any reference to title appeal number 83 of 2015?
Yes. In the same paragraph.
आपको ऑर्डर शीट पढ़ के पता नहीं चला कि कौन से ऑर्डर से कौन मानने वाली बात है।
Miss हो गया मेरे से। I went through the other part. I forgot to do it.
बताइए।
Thereafter, now two things your edition may bear in mind is that 165 was exercised so as to get those two GPAs on record.
You also brought on record.
I only brought it on. Two GPAs I'm talking about, not the records of the title suit. The records of the title suit, there is no actual explicit mention of which provision of law was invoked, but there is no other way except for 165 for the learned court to do it. So the learned court, I am assuming, exercised powers under 165 without conforming to the threshold and the parameters under section 33, without putting any questions to me under 145 read with 154, and without proper exercise of 165 of the Evidence Act. It called for the records on 25/4/2023 on the same day pronounced the judgment upon perusal, and half of the judgment is based on those records. So I had no way of clarifying or substantiating any claim that was being assumed that I was making on behalf of those records.
Only two documents were marked. One was the sale deed number 6352 dated 21/11/1939.
5 documents were marked. They were marked as 1 by 1 and by 2, and thereafter 4 by 1, 4 by 2, and 4 by 3. There were 5 sale deeds that were marked. They were dated 1939 and 1979.
Yes. So these are all registered sale deeds which have been marked.
Yes. But that does not give a, I mean, the 165, it is being invoked. I'll come to the judgments also. But if 165 is being invoked, the purpose of 165 is to ascertain the truth. Now, thereafter, and it has wide powers. It is supplementing 311 CRPC also, the judgments were not on that. But it has wide powers.
These sale deeds, they find reference in your sale deeds or they do not?
The sale deed 1939 and 1972, they find reference in my power of attorney.
In your power of attorney, they find reference.
Yes.
And it
Two of
must
them.
be there in your sale deed also.
No, not in this. But they find reference to my power in my power of attorney. Only 2 of them, 3 by 1 and 3 by 2. I understand that I have myself mentioned title suit 139 of 2012 and the appeal, and so the obvious understanding is that there is no clear prejudice. But if the learned court wants to ascertain truthfulness of facts based on the recital of those sale deeds, and assume a position whereby it says that my title is disproved. The learned court has gone so far as to say not that my title is not proved, but that it has been disproved, then I ought to have been given an opportunity. Why call for the records on the same day, pronounce the judgment on the same day, and then accuse me of lapses of not being able to substantiate?
You
on the
see,
basis of
your registered deed is making reference of sale deed dated 15/11/39, 21/11/39. There are references of these sale deeds.
Yes,
Then all these sale deeds are mentioned in your sale deed also. So it is an
It
undisputed.
is a matter of
document.
record. If it is mentioned, then it is mentioned. I am not on that.
It is
But if the
mentioned.
learned court wants to go into the recital and say that my title is disproved, then why call for it on the same day and then pronounce the judgment and then say you are not able to
You are in
substantiate?
first appeal, no?
Yes.
Right. You are deriving title from these sale deeds,
Yes.
which are referred to in your sale deeds also, right?
I mean,
Now you
yes.
tell us that it is the same property which you have purchased. It's a back-to-back sale deed, no? If it is
Yes.
back-to-back
They
sale
are
deed,
mentioned in my sale deed, yes.
yes. So therefore,
The sale deed leads
therefore
to the
you
power
cannot
of
deny
attorney.
the existence of these sale deeds.
I am not denying the existence.
Therefore,
denying.
if you are basing your title on the basis of earlier sale deeds, and if there is any mismatch, then there is no harm considered. What else is required?
I'll come to the impugned judgment, Your Lordship, to
Now
explain
you read
what.
you read the impugned judgment.
Yes.
Yes,
Findings.
please.
I've made a note of certain paragraphs that I wanted to
You
address.
read it, please.
This findings start from
Point for consideration, right? Issue number 3 is the main thing.
Yes.
Okay.
There is also issue number 2, whether the plaintiff has got valid cause of action. If I can just deal with that first for a second. If your ladyship has.
You are seeking suit for partition, right?
Yes. But from a jointly purchased property, not ancestral property. Any refusal to accept my partition or go ahead with my partition is a valid cause of action.
So defendant is, it was jointly purchased by plaintiff and the defendant.
Yes.
They are not related.
No. If I can just deal with the valid cause of action part first, because that is a smaller issue. If your ladyship has running page 38 of the memo of opinion,
Yes.
that should be internal page 22 of the memo.
Yes.
That is where the learned court deals with cause of action issue. From the inverted commas, after that the plaintiff has brought this suit, such that is a fact. Now, C may be C. Para C may be C.
A also.
Okay, the plaintiff has pleaded at para 9 of the plaint as follows. The cause of action of the present suit arose in the month of January 2020 when the defendant refused to partition of the Schedule A property by means and bounds and has been continuing ever since within jurisdiction of this court. D. The plaintiff has brought this suit for partition against the defendant for two purposes. One, for declaring her share to the extent of area 7 kattha over the Schedule A property of the plaint which is purchased jointly by the plaintiff and the defendant by registered sale deed number 6594 dated 9511, followed with deed of rectification number 9418 dated 1711, and another for carving out her share by means and bounds. C. It is admitted case of the plaintiff that the sale deed itself contains the recital regarding specific share of the plaintiff and the defendant. So the question is, why this suit for declaration of plaintiff share as claimed? There is nothing on record which shows that the defendant has denied her share in the suit property as mentioned in the sale deed. Rather, the plaintiff has stated that the defendant wants to purchase her share also, means he has no confusion about the share of the plaintiff. But since the vendors having no right to sell the property execute the GPA, the sale deed exhibit 1 is itself void ab initio.
Since the vendors have no right to
Yes.
sell the property. Who were the vendors?
The vendor is through the general power of attorney. The
General power of attorney is not a vendor.
through
Who is
the,
the vendor?
the vendors are Sabapati Yadav and 14 others who are descendants of Rameshwar Gowla.
Ramesh?
Rameshwar Gowla,
What?
the person who had bought subsequent to compromise who had got the property.
Yes, further.
Further, the plaintiff is silent about the date, time, place, and manner in which the plaintiff requested the defendant to get the property of the same in partition by means and bounds. Though not required statutorily, the plaintiff could have sent letter personally or through advocate to the defendant to get the suit property partition by means and bounds to avoid litigation. There is nothing in the plaint showing any such effort by the plaintiff. The witnesses are also silent on facts giving cause of action, except the general fact that the plaintiff asked for partition and defendant denied. Considering the facts and circumstances and the materials available and discussed in detail, it will be no shocking if it is said that the defendant intentionally not appeared in the suit, as he also wanted the suit to be decreed, giving confirmation on the same in Exhibit 1 by the court, which is not otherwise executable by the vendors directly or through power of attorney and is void ab initio. Hence, in the result, it is held that the plaintiff is not able to prove the valid cause of action for instituting the present suit. Hence, point number 2 is decided against the plaintiff. Now, if your ladyship has my plaint, para 7, 8, 9 of my plaint.
That's right.
That
This is wrongly decided.
Yes.
Further,
That valid.
point number 3.
Yes. Point number 3, I had made a mark for myself on certain, because it is a fairly longish judgment with certain places that have adverse inferences. It will depend on how your ladyship wants me to proceed. I had made certain marks and I wanted to take your ladyship on those points specifically. I can read the whole thing.
You read quickly. Read it, please.
Findings start from page 24.
I'm at page 20. Internal page 4. How many witnesses were examined?
3.
3. Okay. Plaintiff was PW3.
Yes.
Who is Vijay Shankar Prasad? The husband.
The husband.
And also the power of attorney holder.
Yes.
Okay.
PW2 is an independent.
Independent and formal?
No, he has also proved the cause of action.
Okay. He has proved the cause of action. There is no cross-examination.
The court has put questions.
Court had put questions. Otherwise, there is no cross-examination from the
Expert.
expert. Now let us see the exhibits.
That is also something your ladyship would consider, that if the court is laboring under certain apprehension or certain impression is created, there was nothing stopping the learned court from proper exercise of 165,
Let's see.
from putting certain questions to gain clarity.
We'll see that. Original registered deed of rectification.
Both the deeds, the exhibit 1 and 1A are filed in the original.
Okay.
So they would be primary evidence.
1 and 1.
Yes. The rest are certified.
So, in spite of the fact that you were joint owners of the property, but you were having the original certificate,
Yes.
right?
Yes.
So, other side defendant did not even have the original certificate for
No.
himself.
No. We have not pleaded that there were two
Then
made or something.
you
like that.
also filed the certified copy of the title suit, 139. of
And the appeal also.
and the
4/5.
appeal also. This is exhibit 4 and 4 by
Since your ladyship is on exhibits,
Does this title suit refer to the original sale deed of 139? Are you a party to this title suit?
yes.
This 139 of
Yes.
12?
Yes.
Okay. Does it refer to the original sale deed of 139?
From
Of
1939.
1939?
Those documents were exhibited by the plaintiff in that case, but they had no bearing to the issue at hand.
No,
in the
let's see.
title.
But there must have been some discussion on that.
Yes.
Let us see that. Exhibit 4, right?
It's 4 and 4 by this. The exhibit 4 will be the suit, the 4 by the appeal.
Let us see the issues framed.
It is at page 6 of the.
It was with respect to the same suit property.
No, that was the concession here. And that your ladyship
No, the
would find
suit was in connection with the same suit property.
the suit was not for a declaratory relief. The suit was for clarification that that suit property that belonged to the plaintiff in this case was actually not part of my suit property that is in this case. And thereafter, in the appeal, the plaintiff, the appellant there, conceded that he was laboring under some false impression, and thereafter it was clarified. That is there in the appellate judgment also. The part that I think your ladyship wants to see is that para 6 of that suit judgment, exhibit 4. That has a reference to 635 to 6286.
Yes.
Those are that is only some basic references have been made. The actual concession is at the appellate stage.
Okay, let us see.
That is at page 10 of that judgment, para 15 of the appellate court judgment. So on analyzing the aforesaid, on analyzing the aforesaid evidence, it is crystal clear that there is house of Dr. P. M. Gudgudia in between Schedule A and Schedule B, and the boundary of Schedule A is quite different from Schedule B, and both the lands are not adjacent to each other. PW1 in para 74 has clearly stated that he has no claim over Schedule B. In para 75, he has stated that he has wrongly brought the suit against the defendants. Both the plaintiff and the defendant here were defendants in that case. The defendant number 2 in para 59 has stated that towards north of the house of Gudgudia, he has no claim over the land. It shows that neither the plaintiff has claimed over the land of defendant 1 and 2, Schedule B land, nor the defendant number 1 and 2 have claimed over land of plaintiff, Schedule A land. So, on that basis, this suit was final.
So Schedule A ultimately went to
The plaintiff in that
the
case.
plaintiff,
And Schedule B comes to me.
A to the plaintiff, Schedule B to the
Defendants.
defendant 1 and 2.
Yes. They are the plaintiffs here, the plaintiff and defendant here.
Okay. Alright. So Schedule B was declared to be your.
It was not declared, it was simply clarified that he has no claim for it. I would be fair and say that there was no such declaration.
And the Schedule B property in that case was the same as the suit property.
One
in
of the
precedence.
plots was this.
One of them.
He was not even claiming the other plots, he was claiming 1037. That is what gave rise to that dispute.
The Schedule B was 1037.
Yes.
Okay. Let us read the judgment. What?
He impugned the
You read the oral evidences. Oral evidences have been correctly recorded or something has been missed out?
no, more or less.
Correctly recorded. Read it, please.
There are one or two issues that I will come to those when I come to
You
them.
read it.
Para 11. The oral evidence on behalf of the plaintiff is as follows. PW1 Vijay Shankar Prasad, husband of the plaintiff, has stated in his evidence by way of affidavit that he knows both the parties and the disputed property also. The disputed property is land on building in Mauza Dhanbad, Mauza number 51, Khata number 61 and 80, plot numbers 1030, 1034, 1035, 1036 and 1037, total area 15.42 decimal, in which 4 rooms and 1 storeroom are constructed. The disputed land is purchased jointly by both the parties, on which both the parties are having joint possession. The owner of the disputed property were Sabapati Devi and others who had given power of attorney to this witness wide number 4 Roman 4-256 dated 8/4/11 and Roman 4-261 dated 11/4/2011. This I think should be 361. Who sold the disputed property to both the parties by registered sale deed number 6594 dated 9/5/2011 on the basis of the aforesaid power of attorney and gave possession jointly to them. By way of the aforesaid sale deed, he sold 9 kathas to plaintiff and 2 kathas 5.5 chatak in favor of the defendant. It is further stated that because of some errors in the original sale deed regarding the khata number, he executed one rectification deed number 9418 dated 17/11 in favor of both the parties. It is further stated that both the parties got the suit property mutated in their names and are paying rent to the state being in joint possession of the same. The witness further stated that one Virendra Kumar Bhatia has filed title suit number 139 of 2012 against the parties of this suit regarding the disputed property of this suit in which both the parties of this suit filed joint written statement in that suit. Learned Civil Judge Senior Division 7 Dhanbad was pleased to dismiss the suit of the plaintiff Virendra Kumar Bhatia by judgment dated 17/6/2015, against which Virendra Kumar Bhatia filed title appeal number 83 of 2015, which was also dismissed by judgment dated 27/6/2016 by the Learned Appellate Court of District Judge 4, Dhanbad. It is further stated that both the parties are in joint possession of the disputed property, and till date they have not partitioned the disputed property, in which the plaintiff is having 7 katta share and defendant is having 2 katta 5.5 katta share. Since the suit is running ex parte, none is there on the other side to cross-examine the witness. In answer to court question, the witness has stated that he has filed this affidavit on which he has put his signature. He could not produce Sabapati, Yadav, etc. as witness who had given him power of attorney. He stated that all vendors are Yadav and they are having katal on disputed land. He stated that Virendra Kumar Bhatia also claims on suit property. He stated that the plaintiff is his wife. He executed sale deed in his favor of his wife, in favor of his wife and the defendant. He could not say when the vendor Sabapati Devi and others left the Katal and shifted to Chhapra. However, in the year 2011, he went to Chhapra, Bihar to take the power of attorney. 2. PW2 Kamlesh Shah is an independent witness who is also resident of Gandhi.
What is the date of power of attorney?
The two dates are, the 4 of 256 is dated 8/4/2011 and 4 of 361 is dated 11/4/2011.
8/4/2011 and
11/4/2011.
Yes, please. Why did this PW2 say that the property was sold in 2008-9? Carry on, read it please.
PW2 Kamlesh Shah is an independent witness who is also a resident of Gandhinagar, TS Dhansar, Dhanbad. He has stated that he has filed the affidavit in which he put his signatures. He has also given the same details of the suit property in his affidavit. He has also stated that both the parties of the suit purchased the property jointly and are in joint possession. Till date, they have not partitioned the property. The plaintiff is having 7 katta share, defendant is having 2 kattas 5.5 chatak share. In answer to court question, the witness has stated that the defendant Dharamiraj Yadav wants to purchase the property of the share of the plaintiff, but the plaintiff does not want to sell the same and therefore she has filed this case. He stated that the defendant is having knowledge of this case. At para 4 stated that the suit property was of Sabapati Yadav and others who sold the same in the year 2008 and 9 and went to Chhapra.
8-9 का कहानी कहाँ से?
This has been stated and it has been considered by the learned court. Independent witness has somehow stated 8 months.
आगे पढ़िए. This is not an error.
He has
This
stated,
is what he has stated.
yes.
आगे पढ़िए.
PW3 is Suman Devi, plaintiff. In her evidence by way of affidavit, she stated that she has complete knowledge about this case and the suit property. In her affidavit, she has stated the same facts as PW1 till para 11. Thereafter, she stated at para 12 to 15 of the affidavit regarding documents Exhibit 1 to 3. Regarding Exhibit 1, she stated that this is original registered sale deed 6594 dated 9/5/2011, which is drafted by deed writer Ghanshyam Prasad. It is computer typed. Vijay Shankar Prasad has signed on each page of it. The witness and Dharamiraj Yadav have also signed on it. Jai Prakash Mishra and Govind Ram have signed as witnesses. The deed writer Ghanshyam Prasad and his assistant Raj Nandan Mishra also signed on it. She identified all the signatures. Regarding Exhibit 1/A, she stated that this is original rectification deed number 9418 dated 1/3/11. It is drafted by deed writer Ghanshyam Prasad. Vijay Shankar Prasad has signed on each page of it. Defendant Dharamraj Yadav and Jai Prakash Mishra and Govind Ram signed on it, which she identified. Regarding Exhibit 2 and 2/A, she stated that these are certified copies of order sheets of mutation case number 360/3/1617 and the correction slip. Regarding Exhibit 3, she stated that this is original government rent receipt number such and such dated 3/6/2016, which is written and signed by Revenue Sub Inspector Santosh Mishra, which she identifies. In answer to court question, The witness has stated that she filed this affidavit on which she put her signature. She stated that she got opportunity to meet vendors, Sabapati Yadav and others. They came to her house, and when the dealing was going on, they were total 12 to 14 persons, all old age. They stated that they could not come again, and therefore her husband went to Chapra on their request to take the power. Dharamraj Yadav, whose co-purchaser, forcefully wants to purchase the property of her share, but she does not want to sell the same, and therefore brought this suit for partition. This should litigation, while adjudicating the cause of action issue, is part of litigation is considered. As far as the explanation that has been given to court question, that also will be considered. May I continue? Submission argument on behalf of the plaintiff. The learned counsel of the plaintiff placed his oral arguments where he submitted that the plaintiff has simply brought this suit to get the property in the sale deed exhibit 1 series partition to the extent of her share. As per the sale deed at page 7, which is 7 katta share of plaintiff and 2 kattas 5.5 chatta share of defendant. When asked regarding manipulation in the sale deed exhibit 1, he submitted that due to confusion in the khata number after the sale deed exhibit 1 is typed, khata number 80 is made 86, but the same is got corrected by executing rectification deed exhibit 1/A. He submitted that the fact of the suit of Virendra Kumar Bhatia is brought in the suit because it is related to part of the suit property in the suit. It is further submitted that the plaintiff has further proved the possession by bringing certified copy of mutation order along with correction slip and original rent receipt. Now, finding. Para 13. Let us take up the issues one by one for complete adjudication of the suit. I would like to start with the main point of determination of the suit, that is point number 3, whether the plaintiff is entitled for a degree of declaration of 7 katta share in the suit property as paid, which is purchased by the plaintiff through sale deed exhibit 1 followed by rectification deed exhibit 1/1 through power of attorney. A. The plaintiff has brought this suit for partition of schedule A property, which is purchased by the plaintiff Suman Devi and defendant Dharamraj Yadav in their joint names through registered sale deed exhibit 1 followed by rectification deed exhibit 1/A through power of attorney holders of vendors, namely Vijay Shankar Prasad. B. So the plaintiff is required to prove her title of the suit property, entitling her for its partition and ultimately the title of vendors by producing related document. Further, since the power of attorney holder of the vendors executed the same deed, the documents giving power are also required to be produced and proved by the plaintiff. The first part of this statement, I have objection to that. I will come to by way of the judgments that I have produced. That I am required to, despite an ex parte partition suit, required to prove my title.
But you have, just a moment, you have yourself produced the power of attorney, right?
Not myself. I was directed to under 162.
No, the order sheet says that you have produced it.
Yes, upon direction under
Yes.
162.
Yes, if you are referring to your power of attorney and if the court asks you to produce it, and you have produced it, what is?
Yes, I myself produced it. Yes.
That's right. You yourself have produced
Yes,
this power
yes.
of attorney.
In my
because it
possession,
was
I produced. Yes.
in my possession, and you produce one more power of attorney which was not even mentioned in the claim.
Yes.
It was not mentioned. You yourself produced it,
Yes.
right? If a person is acting as a power of attorney through the power of attorney, and if the sale deed is through the power of attorney, and they want to, what the court wants to see, there is what objection can you have to that?
My only objection is with the conclusion drawn.
You dispute the power of attorney also.
No, my conclusion is my objection is that the conclusion drawn by the learned court may be, with due respect, faulty to the extent that the learned court goes ahead and says the title is disproved. Not that I have not been able to prove it, that it is disproved. That I want to come to eventually in judgment. And for
So
that, I
at
would
best,
have-
the court could have said that you have not been able to prove
Yes, yes,
it. At best.
at best.
So whatever the court record was called for suo moto, if those documents are, if those evidences are segregated,
Yes.
then what remains is that you have not been able to
Prove my
that.
title, and hence I may not be entitled for a partition as such. But to go ahead and say that my title is disproved, my mutation records, everything, it is set to naught.
That's right.
Because that has not even been discussed in the
You are not
judgment.
seeking a declaration of title.
I am not seeking a declaration of
You are
title,
seeking a partition.
a partition.
So the judgment in the suit is beyond the pleadings, because you are not seeking a
Beyond the
declaration of
issues
title.
also.
Beyond the
it is
issues, beyond the pleadings, and since you are not seeking declaration of title and there is a registered deed in your favor, the court would not have gone beyond that and said that and nobody has challenged the sale deed. That amounts to setting at naught the sale deed itself
Yes. Without a cancellation.
without a cancellation, without any prayer for cancellation.
All that has been taken as my submission in the written notes. But other than that, the other aspect of the matter, principles of natural justice. Same date the learned court calls
No,
for.
you see, if you say that you have any objection to that, they could not have done it. You forget about it. Whatever documents the court has called for, suo moto, you don't want to rely upon that, nor you want any adjudication on that.
But that is the fulcrum on which the learned court bases its immunity.
No, the court
So
is
to demonstrate
the court
any
is-
illegality, I would.
The court goes on to discuss that the documents submitted by you, it was not clear as to which portion of the property was sold by Gidhari Lal Agarwal.
On the last date also, if your ladyship perhaps recollects, I said so myself that there seems to be, without making any concession, not on the record,
Yes.
but without making any concession, there seems to be some issue. But that is not a free pass to the learned court to call for records on the same day.
That's right. So we will
And
see
then go
that
ahead and pass
we
a
will
judgment.
decide this appeal irrespective of those documents.
Whether those could be severed is the adjudication that would be required. That is absolutely right. Whether that part of of this impugned judgment can be severed without going into
You
164,
see, now in a
165
case which is an ex parte judgment, right? Now it has to be decided on the basis of whatever pleadings and material was brought on record by you.
Yes.
We will decide it on the basis of whatever pleading and material was brought on record by
And
you.
whether in that light the impugned judgment can be sustained. It is one thing to say that I was not able to build my case. It is another thing to say that the impugned judgment can still survive
No.
despite the various
See,
illegalities
that's
committed.
right. So impugned judgment can be modified to the extent that you have not been able to prove your title.
And whether that could be possible in
Why
such a
not?
case, that is for your ladyship. That is your ladyship's discretion. I am not saying that. I am saying my contention is that it could not have been severed because the categorical finding, all the conclusion drawn is because of the 165 invocation where I was not given an
See, we
opportunity.
will say that in order to derive any conclusion with regard to your title,
Yes.
right, certain documents were called for. And there was no need to call for those documents because your title was not in dispute.
Yes.
It was not a title suit
Yes.
for declaration of your title.
Yes.
You were only seeking partition on the basis of a registered sale deed.
That also original I produced.
That's right. It is a registered sale deed. Right? There was nobody to dispute it. Therefore, under such circumstances, whether the court could have gone into the issue of your title, and if the court could not have gone into the issue of your title, so whatever documents have been called for to come to a finding that you never had a title over the property, those are to be, if that finding goes, everything goes.
Here is my contention to what has just fallen from your ladyship. This is only for purpose of assistance. At best, the learned court could have said that on the basis of these documents, this person is not entitled to the partition so sought. That is all. Now the learned court has gone ahead and said that not only I don't have title, my title is disproved. And further gone ahead and said that those documents that were produced by some other person in a suit where the issue was something else in that title suit, I will take those documents, I will call them on this date I will peruse them, and the same date I will pronounce the judgment, and now you tell me why you are not able to substantiate.
That's right.
That is a little overbearing, is what I am saying.
He has gone out of the way.
Yes.
Go ahead.
Starting with the pleadings in the plaint at para C. Starting with the pleadings in the plaint at para 1, it is mentioned that the plaintiff and defendant jointly purchased the suit land by virtue of registered sale deed followed with rectification deed. The original registered sale deed and original registered rectification deed are produced by the plaintiff and the same are marked Exhibit 1 and 1 by A. It is well settled law that presumption of genuineness is attached to the registered sale deed so far as the execution of it is concerned by the parties to the deed, but the facts mentioned in the recital of the deed are required to be proved like any other fact. At para 4 and 5 of the plaintiff has pleaded about the title of the vendors. It is pleaded that Rameshwar Rai Gowla, alias Rameshwar Yadav and others got the Schedule A land by virtue of compromise deed passed in title suit number 6 of 1966. Sabapati Yadav and others are the legal heirs and successors of Rameshwar Rai Gowla, alias Rameshwar Yadav and others. They have sold the suit land to the plaintiff and defendant through the constituted power of attorney holder, namely Vijay Shankar Prasad, by general power of attorney number 4 of 256. Now let us see what documents filed by the plaintiff to prove these facts pleaded as mentioned in the recital of the deed regarding title of the vendor. This compromise deed decree pleaded is not filed by the plaintiff to prove this fact. Further, the general power of attorney mentioned that is general power of attorney number 4 of 256 was not filed by the plaintiff on its own thereafter. Now I would like to mention in detail the facts mentioned in the recital of the sale deed. In Exhibit 1 sale deed, page 1 and 2 are details of the parties to the deed mentioned in the table of exhibit documents. It transpires that two general power of attorneys GP and short executed by the vendors, number 4256 dated 8/4/2011, number 4261 dated 11/4/2011, as stated above. In the plate at para 5, there is mention of only one GPA number Roman 4256, and that was not filed by the plaintiff. However, when asked by the court during final arguments, the plaintiff produced the two GPAs mentioned in the sale deed. It is recited at page 3 of the sale deed as follows, quoted.
You see, the power of attorney was for khata number 80, and in the sale deed it was written as khata number 86. Was the power of attorney also amended?
No, the power of attorney always was for 80. Incorrectly in the sale deed, first it was typed as 80, then there was some issue, they corrected it to 86
How?
by hand.
How is it possible?
That
The
is why the
power of
rectification.
attorney, if the power of attorney
Yes.
was for khata number 80,
Then what prompted them to make that change?
then,
to
then
86?
unless that power of attorney is also amended, followed by a deed of rectification, how the
Power of attorney
deed of rectification was also executed by the power of attorney?
Yes, by the power of attorney. Yes.
Then how?
Therefore, it is reconciled. Why I am saying this? The power of attorneys were executed in 4/2011. In April 2011. Subsequently, both the sale deeds both the sale deeds are executed in May. And right after a few days after that, 11/5, the rectification is also executed.
Who executed the rectification?
The same parties that executed the sale
Same
deed
parties, or it is the power of attorney who has executed?
No, the power of attorney holder is the person through which the sale deed has been executed.
Both the rectification also?
Yes, both.
So if the power of attorney reveals only khata number 80, then under what circumstances khata number 86 can be amended?
Because it was incorrectly written as 86.
Then the power of attorney also was required to be rectified.
The power of attorney remained at 80, 61 and 80. Due
If
to
the
a human...
power, no. You see, if I give you power of attorney to sell property A, and actually I intended to give with respect to property B, if the power of attorney sells property B instead of property A, whatever is mentioned in his power of attorney, then under such circumstances, how the sale of property B can be justified through the power of attorney?
This is not the case here for the ladyship's example.
We are in first appeal, we are looking at it.
Yes, this is not the case. This example would not apply in this case because here I always intended the power of attorney holder always intended to execute sale in favor with respect to plot A because he himself had only power of plot A. Incorrectly, plot B was missed by human error, typographical error. It was mentioned as plot B.
Even if it is a typographical error,
Yes.
then that typographical error has to be rectified.
It was rectified subsequently by way of a rectification deed.
By the rectification deed, that power of attorney holder himself has rectified it,
Yes.
right? By that time, did he get his power rectified?
The power was always correct. It was the deed
Power
of sale
was
that was
only
incorrect.
power was only in connection with khata number 80. Power of attorney
61 and
is
80.
exhibit.
Both.
61 and 80.
Yes.
Then unless the power is amended to be 61 and 86, how that person can execute a deed in connection with 86?
86 was never sold. Only 80 was sold.
No, typographical error.
That was 86 was the typographical error. It was to be corrected to 80.
Nahi. Exhibit 1 is wrongly corrected by use of pen to 86.
Yes, 286. That is how the learned court has worded it. It has been corrected to 86 by hand. That is the human error. That was thereafter rectified and changed to 80. That is the rectification.
You have not produced a certified copy of the deeds.
Yes, both original.
Original. Certified copy you have not
No,
produced.
they are primary evidence. Certified copy to secondary evidence, then the presumption certificate.
let us see your power of attorney and the deeds. First, the rectification deed.
Exhibit 1/8.
Let us see it in sequence, right? Power of attorney is exhibit.
Power of attorney is exhibit Roman 1. The two are Roman 1 and 2.
Just a moment. The power of attorney holder has also been examined.
Yes.
He has been examined as PW1.
Yes.
He refers to khata number 61 and 80.
Yes.
And he refers to both the
Power of attorney.
power of attorneys.
Yes.
He is not okay. It is not his evidence that he was entitled to execute in connection with khata number 86.
No. It is no one's case.
It is no
No one's
case. Okay. Now let us see. This PW2 is also talking about 61 and 80.
Yes.
Correct?
Yes. Religion was asking me where he said 8 and 9, that is para 4 of his cross examination. It says
Para 4 of cross examination of
PW2.
PW2. 2008. Okay. Then you have
PW3.
now let us see the exhibits. Power of attorney.
So it is exhibit Roman 1.
Exhibit Roman 1. Cited here. Exhibit Roman 1. Right. Where is the khata number mentioned?
It is at page 5.
Khata number 61 and 80. Correct?
Yes. The second power of attorney.
Just a moment. Why was there a requirement of 2 power of attorney?
इसमें सेकंड वाले में खाली 0.826 डेसिमल included.
Where is the second
Part
power
by
of
part.
attorney?
Page 8 of that second power, exhibit Roman 2.
Exhibit 1. Exhibit 1. Page number 8.
Yes. No, sorry. It's page number 3.
Page number 3. It's the same thing.
I think the parties are different. So, Fagu Gop and these people. The first one was executed by Sabapati Yadav and the second one was by Fagu Gop. That is why there are 2 power of attorneys.
2 power of attorneys was given by the same person.
No, to the same person.
Sorry?
To the
To
same
the same person. Right. Where is the first deed?
It is exhibit 1. The
Let's have a look at it. What is the description of the property?
This is at page 4 of the COD. That is by 61 and 86 has been written.
So this property relating to 86 could not have been executed on the strength of this power of attorney.
Yes.
Right?
Thereafter the
Where is the deed of rectification?
exhibit 2, page 2 of that.
Let us read it.
And whereas
Yes, certain mistake.
certain mistaken and inaccuracies have accidentally mistaken inadvertently crept in the principal deed which require rectification in manner hereinafter appearing. Now this witnesses that the principal deed shall be rectified and corrected in the following manner. Namely, in the schedule in the principal deed for the words Khata number 86, insert of the words Khata number 80 that has rectified and modified as aforesaid, the principal deed shall remain in force and effect in page number 3 of the principal deed, second line after the word 86, insert the word 80. And in page 4 in the line 2nd and 4 of the principal deed after the word 86, insert the word 80.
How after the word 86 it will be inserted?
very poorly drafted.
Poorly drafted. How after the word 86? It means that 86 and 80 both will remain.
Yes, as you know.
क्या हो सकता है ना? Now we forget about everything. किस
My-
तरह का rectification भी?
My contention with respect to, there are two limbs of my argument, you ladies should appreciate.
So
I
this is-
understand
this-
everything that is wrong with the case.
Okay.
I understand everything that is wrong with the case and there is plenty. I am saying
और कौन सा document? इसके अलावा
the
क्या?
rest of the mutation
No,
documents.
let us see that because there is an allegation in connection with mutation records also. Mutation is 61 and 80.
Those are correct. Those
Let us have a
record.
look.
Yes. Exhibit
Mutation
3.
is 60. You see, ये जो mutation है ना, rectification के पहले का mutation है सारा. Correct? सारा उस deed से लेकर mutation हुआ. ठीक है? सारा mutation का document is based on that original deed. इसीलिए
एक सिग्नेचर है 1711 का सेम डेट का.
उससे क्या फर्क है? बात ये जो डीड आप प्रोड्यूस करेंगे उसी के बेसिस पे म्यूटेशन होगा ना. तो आपने जो प्रोड्यूस किया उसके बेसिस पे म्यूटेशन हो गया आपका. ऑन द
Mutation
स्पॉट
तो 80 का ही हुआ.
80 का ही हो रहा है.
म्यूटेशन 80 का ही हुआ था.
80 का ही हो रहा है. आपका रेक्टिफिकेशन में 81 एंड 86 दोनों इंक्लूड हो गए.
वो होना चाहिए था. इट हैज टू बी रेक्टिफाइड इंस्टेड इन प्लेस
फिर
ऑफ
से
86.
रेक्टिफाई कराइए ना.
In place
क्या
of
ही हो
86,
सकता है?
it should be 80.
इसका क्या हो सकता है बताइए? इसका तो कुछ हो नहीं सकता. पोरली वर्डेड में यू आर सफरिंग. आगे जजमेंट पढ़. चलिए बढ़िया आगे.
From page 25.
Rather, you can straight away come to para number 2 at page number 28. बाकी मैंने पढ़ लिया. आप जितना पढ़ रहे थे उतना देर में मैंने पढ़ लिया उसको. ठीक है?
Three paragraphs before that, if I may just draw
Yes,
your attention.
sure.
This adverse inferences, basically what I want to demonstrate are adverse inferences that were not called for at this time. Page 26, page 26 of the impugned judgment, Roman 3, that is a subparagraph of 13.1. It is further noted that Gidharilal Agarwal has purchased some portion of the land, meaning thereby out of the said suit scheduled property, scheduled land of the said deed, some portion was purchased by Gidhar, but is not mentioned what was the portion, and also not mentioned by whom he purchased. For the sale deed mentioned there of the year 1939 are
This
also
is
not
correct.
produced by the claimant. I'm talking. Then J of 4.
No, let us pause here for a moment.
Yes.
This finding is correct. that some portion was purchased
Yes.
and no portion was mentioned.
Some exact what portion was purchased is not been mentioned, that is correct. My contention in this regard is that the learned court has itself called for the documents of the 39 CLD. Thereafter, it has gone ahead and gone into the recital of those documents. There is no occasion to draw such an adverse inference as part of the findings of the learned court. Thereafter, next.
Just a moment. You see, in your recital also it is mentioned. In your deed itself it is mentioned that some portion has been purchased by Gidari Lal.
Yes.
So,
Yes,
it is a part of your deed. You
But-
forget about that.
It is part of the findings of the learned court.
It is a part of your deed
It is part
also.
of my deed,
It is a
yes.
part of your recital in the deed.
Yes.
So what's wrong about it? You yourself, in order to prove the case, it was your duty to produce the documents.
Yes.
But the court has gone out of the way to get hold of those documents. And in your deed also it is mentioned some portion was purchased. So it is absolutely vague. The description of the property in your deed is absolutely vague. Some portion has been purchased. What is this?
Page 28. N.
And you just see in your deed, you yourself make this correction as 86. You
Yes.
could not have done it.
That by hand.
You could not have done it.
Could not. Should not have done it.
That is tampering with the document. It is a tempered document that you have produced.
There was a rectification subsequently.
Maybe
but
maybe
I
rectification.
won't call it a tampering, but yes, it should
It
not
is
have been.
tempering. And what was rectified was 81 and 80 and 86 both was included.
So instead of
So this is a tempered document outright. It is a tempered document.
because I have not suppressed that fact
What suppressed?
that there was some sort of mistake.
So
There is no
Mistake.
interpolation as such, but
you
yes,
can't, you just come.
I am admitting to the point that they are poorly drafted documents, all of them. I am saying on the point of illegality in the impugned judgment, that is my case. I am on the illegality in the impugned judgment. If your ladyship has N, now this is something that is again the learned court has stretched itself beyond. In page 8 of the deed, the witnesses appear to have signed a Jayaprakash Mishra, Govindram and Ghanshyam Ram. As per the evidence of PW3, plaintiff at para 12 in her affidavit exhibit 1 states it is signed by the deed writer Ghanshyam Prasad and his assistant Raj Nandan Mishra, but one can see from the naked eye that both these signatures are made by same persons. Without any calling for any expert evidence, without so much as a close scrutiny, and on what basis such an observation was made is something that you ladies should know also. Kindly mark that
Which is that page number?
28. M.
And
M.
page number 28.
Yes, running page 28. Internal page 12 of the journal.
You just read this also, page 27, Roman 1.
So as per the recital at page 4, Rameshwar Rai Gowla and other owners the suit khatas and plots from Girdhari Lal Agarwal. This sentence is so incomplete and the fact is not clear as regards the status relationship of Rameshwar Rai Gowla and Girdhari Lal Agarwal. But it appears that Rameshwar Rai Gowla getting title from Girdhari Lal Agarwal. But how, not clear. Whereas in page 3 of recital, Rameshwar Rao Gowla is shown related to last service element, no such document produced by the plaintiff.
You read Roman 3.
It is to be noted that all important figures are overwritten. Khata number 80 at all places made 86, mutation case number and Thoka number as mentioned above at the relevant place. What has fallen from your ladyship? Now, page 28. May I start with para 2?
Yes.
As stated above, it is only when the court asked about the GP in favor of Vijay Shankar Prasad during final arguments, finding it not filed by the plaintiff filed a certified copy of the registered GPA number 4 of 256 dated 8/4/2011 and 4 of 261 dated 11/4/2011, which are not prayed to be marked exhibits on behalf of the plaintiff and therefore marked exhibits by the court invoking section 165 of the
So
evidence.
you file it yourself?
Yes.
And the court ultimately
Marked it as, but it invoked powers. I will come to 165 and what
But
actually.
it was
powers.
filed by you.
Yes. I mean, the court did not call for records from another case. It asked me to file. I filed.
You filed it.
Yes. Exhibit finding it relevant to be seen to decide to sue. Para 3. Exhibit 1 is the certified copy of GPA wide number 256 T-3990 dated 8/4/2011, registered at District Sub Registrar Saran Chakra, Bihar, executed by the vendors number 1 to 14 in favor of PW1 Vijay Shankar Prasad, who is the husband of the plaintiff. It is regarding land of Khata number 6180 in plot numbers 1030, 1034, 1035, 1036, 1037, area 9 kathas, 5.5 dhur, 6678 square feet, 15.33 decimal, Thana number 51, Dhanbad, within municipal area Dhanbad, ward number 20, old and 21 new, with boundary north, house of Dr. P.M. Gurgutia, south, East Gully, east, telephone exchange road, west, railway. In the same way, exhibit 2 is the general power of attorney executed by vendor number 15, Fagu Yadav, in favor of PW1 Vijay Shankar Prasad. This also contains substantially similar statements. The court failed to understand when the GPA was given for the land. This is exactly what the lady should have said. This is also, the court failed to understand when the GPA was given for the lands of Khata number 61 and 80 as mentioned in para 5 of the GPA, and what was the reason and by what authority. Khata number 80 typed in the sale deed exhibit 1 is wrongly corrected by use of pen to 86, and sale deed for Khata number 86 executed by power of attorney for which he had no power, and for rectification of which again a deed of rectification exhibit 1 by A was executed and registered as stated by the learned counsel for the plaintiff during argument, but there is no pleading to this effect that what was the defect which was required to be rectified or why there was need for rectification deed. This we have stated, but somehow it is still not. Since the sale deed exhibit 1 was executed by the power of attorney holder who is none but the husband of the plaintiff and not the owner directly, this fact was required to be pleaded and or proved by the plaintiff, particularly in the circumstances when the power of attorney holder is examined as PW1 in this suit, because he was the best person to answer this question, but he has not. Not even when the court asked him orally during the arguments, he had just shown ignorance. Further, I would like to reproduce here relevant para 3 unnumbered in page 2 of deed of rectification, which is as follows. This we have read it. I mean, continue with the next. Apparently, last line. Apparently, in the deed, 80 is to be inserted in the place of 86 in the schedule of type of deed only, but in page 3 and 4 of the deed, where the facts about the title of vendors are recited, at 3 places 80 is to be inserted after word 86. So, is it that the parties to the deed intends to enter Khata number 80 and 86 in the stated exhibit 1? This is actually appearing from the plaint regarding of the deed of rectification. As stated above, the power of holder had no right to execute sale deed of Khata number 86 beyond the details of land given in the GPA. Plaintiff and or her husband / GPA holder are silent in this aspect. Para 6. Now coming to the exhibits 1 and 2 GPAs to see the details of land in relation to which GPAs are given and also to see what is mentioned regarding title of vendors. At para 5 of GPA, the details of land for which GPA given are mentioned, details given earlier. It is mentioned in the recital that the land is of Rayati Khata, which is purchased by Gedhari Lal Agarwal and others from Khatyani Rayats by registered sale deed number 6352 dated 21/11/1939 and 6286 dated 15/11/1939. Writing suit number 6 of 1966 contested before the court of Sub-Judge First Dhanbad between legal heirs of Girdhari Lal Agarwal, namely Dhanraj Agarwal, and ancestors of vendors, namely Rameshwar Rai Gowla, against which Rameshwar Rai Gowla filed appeal before Honorable Patna High Court vide FA 825 of 1971, in which there was a compromise between first party Rameshwar Rai Gowla and others, and second party Dhanraj Agarwal and others, where the first party Rameshwar Rai Gowla and others got 36 feet into 204 feet land out of 63 decimal as per decree Schedule B. After the death of Rameshwar Rai Gowla, his legal heirs got the title and possession on land. So the bare perusal of recital in power of attorney transpires that it is nowhere mentioned about the nature of suit or nature of compromise. The nature of title of Rameshwar Rai Gowla not mentioned. Rameshwar Rai Gowla and others got 36 feet into 204 inch land only if calculated. 204 inch equals 17 feet, so 36 feet into 17 feet is equal to 612 square feet. Therefore, as per recital law in the GPA, the ancestors of vendors Rameshwar Rai Gowla only got 612 square feet land in compromise. Nowhere it is mentioned in the GPA that Rameshwar Rai Gowla was the recorded Rayat or legal heir of the recorded Rayat as mentioned in the sale deed at page 3 ambiguous.
You just come to page 36. You have objections in connection with Exhibit 3, 3 by A, 4, 4 by 2, 4 by 3 and
Yes.
3 by 1.
And para 14, 15, 16.
We see that. So far as exhibits from the other records are concerned, you have objection with regards to all this. Exhibition of sale deed,
Yes.
3 sale deeds, 4 sale deeds.
Yes. In fact, my objection would go on to the GPAs also, because only at the time of final argument the GPAs
You
were
produced
sorted.
it yourself.
I produced it, but I was not given an opportunity to explain the learned
You
court
wanted to cross-examine your GPA.
myself.
I said,
Yes.
you wanted to cross-examine yourself.
Yes.
How, under what provision?
Yes, under 145 read with 154, I'll come to the judgment also. The purpose of 145 read with
You
154
will
is
cross-examine yourself.
not cross-examine,
Then,
but to put questions to myself that are permitted to be put by the adverse party. It will not be in the nature of a cross-examination. It will be in the nature of putting leading questions that are permitted by the adverse party. That is under 145.
these are all, these also are certified or registered GPA.
Yes.
These are registered documents.
I am not objecting to the existence of the document. I have myself produced it. That is proof of existence of document.
Yes.
But in order to prove contents of documents and prove veracity of contents of document, which is the objection as far as the GPAs are concerned, there has to be an opportunity given. Either the learned court puts question to me under 165
You filed it during the course of hearing.
at
and
the
then
stage of final argument.
Maybe at the stage of final argument, your documents are tainted. You have produced forged and fabricated document before the court. You did not produce a certified copy. It's a forged document that amounts to forgery. That amounts to forgery. What are you talking about?
If I am given a chance to explain myself
What explain?
on the
There
recital
is
of
no
the
explanation to
documents,
forgery.
then there can be
There can be no explanation to forgery. It is on the face of it.
that my contention is that it should have that opportunity in the learned
There is no
court.
question of explaining forgery.
No, I'm not.
You got a sale deed executed showing khata number 80, right? And then you had a rectification deed which we have seen it's a defective one completely,
Yes.
right? And then you understood it in your own manner, and then you rectified in your own pen 80 to 86. That amounts to forgery. You were supposed to be completely non-superior.
But my contention remains, I will not repeat myself, my contention remains that despite all this, will the impugned judgment be able to survive? And without considering invocation of powers under 165, which includes not just the deeds produced in title suit and appeal, also the GPAs, will your ladyship be able to sever that part of the judgment and still be able to, that is for adjudication. That is my contention. With respect to putting questions to myself, I will rely on certain judgments, and I would like to demonstrate why it is misunderstood. 145 read with 154. It is Satpal versus Delhi administration. I will come to those. But my basic primary contention is number one, section 33. When the learned court wants to rely upon certain judicial proceedings in the past, then first the parameters and the threshold of section 33 have to be fulfilled. I will come to the judgment of that also.
Okay. So which all provision of Evidence Act are you referring to? First read those provisions and then we'll come to that. You are referring to section?
First section 33 already.
Section 33. You give the list of all the sections you are referring to. Section 33, then?
Sections 145,
145,
154
154,
and 165.
165, right? Read all of them together.
As well as section 22.
Read one by one, right from 22.
Section 22. When oral admissions as to contents of the documents are relevant. Oral admissions as to contents of a document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of such document under the rules hereinafter contained, or unless the genuineness of a document produced is in question.
How is this attracted?
Under 165.
Just a moment. Neither the content of the document nor the genuineness of the document is disputed from your end.
It is disputed by the learned court.
No, it is not disputed from your end.
From my end it is.
But the consequences of the contents and the document has been taken care of by the court. You have not disputed the content or the execution.
I cannot because I am the one producing it. Yes.
So therefore, this is against you.
No. If the learned court is of the considered opinion that this seems to be some sort of interpolation or something is unexplained or there is some apprehension, some anxiety with the learned court, then I should be given an opportunity to produce oral evidence on the point of documentary evidence
We'll
when
take
it is
care of
read
that.
with 160.
Understood. आगे बताइए 33 पढ़ी.
Relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated.
पढ़ी.
Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the facts which it states when the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way by the adverse party or if his presence cannot be obtained without an amount of delay or expense, which under the circumstances of the case the court considers unreasonable, provided that the proceeding was between the same parties or their representatives in interest, that the adverse party in the first proceeding had the right and opportunity to cross-examine, that the questions in issue were substantially the same in the first as in the second proceeding. Explanation. A criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. My case is that if title suit 139 of 2012 is going to be relied upon and any evidence given in that is going to be relied upon in a subsequent judicial proceeding, then the threshold and parameters under
No
33
oral
have to be met.
evidence as such has been relied upon.
But evidence has been.
But no
This
oral
only-
evidence
no,
has
oral,
been.
but this only speaks to evidence.
Please take care.
Particularly with respect to as far as the part where the section says provided that the questions in issue were substantially the same in the first as in the second proceeding. This was not the case,
That's
which is my contention.
No oral evidence has been relied upon. What has been relied upon? Only the certified
Documentary
copies.
evidence.
Certified copies of the registered sentence.
The certified secondary that would be within the category of evidence.
Is it disputed? Certainly it will come within the, it is a documentary evidence, certified copy of registered sentence which have been relied upon from the other records.
The existence is not disputed, but I have not been given an opportunity to prove the contents or to prove the veracity
That's
of the contents.
Further, 145.
Cross-examination as to previous statement made in writing. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. The only way the learned court could have contradicted me on the documents that I have adduced is by putting those documents to me. (154).
Just a minute.
Questions by party to his own witness. The court may, in his discretion, permit the person who calls a witness to put any questions to him which might be put in cross-examination by the adverse party. Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witness.
What is it?
154 is, I will have to come to Satpal to be able to explain my case. What Satpal essentially says is that number one, the purpose of examining one's own witness in the manner that is permitted by the adverse party is number one, not in the nature of a cross-examination. because there is no such thing as unfavorable witness, hostile witness or adverse witness contemplated within our criminal jurisprudence. It is specific, explicitly stated in Satpal itself. And what otherwise it says is it speaks to the purpose of such examination by one.
Whom did you want to put question?
Myself. To be able to explain that either 165 is properly invoked, or if you are not invoking 165, then allow me to cross-examine, to put questions to myself. Either could not have been done because it is all done on the same date.
What else?
165. Judge's power to put questions or order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any questions he pleases, in any form, at any time, of any witness or of the parties, about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the party nor their agent shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to any such question, provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. Provided also that this section shall not authorize any judge to compel any witness to answer any question or to produce any document which such witness would be entitled to refuse to answer or produce under sections 121 to 131 both inclusive, if the questions were asked or the documents were called for by the adverse party, nor shall the judge ask any question which would be improper for any other person to ask under section 144A to 149, nor shall he dispense with primary evidence of any document except in cases herein before accepted. So my contention is that invocation of 165 in all respects was partial at best, because the learned court has powers to put questions also, not just to call for documents, which it does. It does put questions to me. But once it calls for those documents, it does not put any questions to me. And on the same day, I come to the
You come to the judgments.
yes. Just come to the relevant parts, or however.
We do not read judgments without facts. At least I don't read it. 2010 10 SSC 677.
Yes, Ritesh.
It is.
This is with respect to powers under 160.
It is. What was the cause of action before on? It is arising out of an petition.
Yes. Some interdepartmental communications. Thereafter, the Honorable Court had put certain questions, and in an attempt to justify the need for such questions, the Honorable Supreme Court goes into the purpose and object of 160, which is what I wanted to show to you.
Just a minute. It was essentially in connection with possession under urban land ceiling
Another
act.
land ceiling act. Para 37.
Just a minute. You just come to page number, para number 23. 22 and 23.
more so, further examination of the correctness of the aforesaid finding at the behest of the appellants is not desirable for the reasons that they did not disclose even the date of notification under section 10(1) of the 1976 Act. More so, the user of the land could not be changed in view of the provisions of section 10(4) of the 1976 Act. The alleged transfer by the recorded tenure holders in favor of Mayur Sahkari Awas Samiti for the purpose of construction of residential houses is totally illegal. Sale deed in favor of Mayur Sahkari Awas Samiti dated 24/1982 is not on record. There is nothing to establish whether the sale deed was a genuine, forged or fabricated document. Merely making a statement that it was a registered sale deed and therefore it was genuine cannot be accepted. There is no presumption in law. There is nothing to ascertain who had been the transferors and who were the transferees therein. None of the subsequent sale deeds is on record. Therefore, the genuineness of either of the alleged sale deeds can be tested. There are no pleadings as under what circumstances the sale deeds have been executed as to whether the original tenure holders have received any consideration.
So there was neither any pleading nor the sale deed was well annexed, and certain facts were recorded by the court to come to a finding.
I am in complete agreement with
Para
the
37.
Section 165 of the Evidence Act 1872 empowers the court to ask questions relevant, irrelevant, related or unrelated to the case to the party to ascertain the true facts. The party may not answer the question, but it is not permitted to tell the court that the question put to him is irrelevant or the facts the court wants to ascertain are not an issue. Exercise of such a power is necessary for the reason that the judgment of the court is to be based on relevant facts which have been duly proved. A court in any case cannot admit illegal or inadmissible evidence for basing its decision. It is an extraordinary power conferred upon the court to elicit the truth and to act in the interest of justice. A wide discretion has been conferred on the court to act as the exigencies of justice require. Thus, in order to discover or obtain proper proof of the relevant facts, the court can ask the question to the parties concerned at any time and in any form. Every trial is a voyage of discovery in which truth is the quest. Therefore, power is to be exercised with an object to subserve the cause of justice and public interest, and for getting the evidence in aid of a just decision and to uphold the truth. The purpose being to secure justice by full discovery of truth and an accurate knowledge of the facts. The court can put questions to the parties except those which fall within the exceptions contained in the said provision itself. So that is what my contention
Which
is.
all are the exceptions? Which all are the exceptions
That
under 165?
provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. So first proviso is that the fact that has to be, when the judge is asking questions, that fact has to be proved and relevant. In my case, they are both relevant and proved because I am the one who has reduced the general power of attorneys, and the existence, as to the fact of existence of a general power of attorney is proved by virtue of the documentary evidence
ये
itself.
दोनों judgment लाइएगा 2004 volume 4 SCC 158 and AIR 1968 Supreme Court 178.
The exceptions are that I will not be compelled to answer if I don't want to answer.
We'll see that. But the existence of the documents, the registered deed and the power of attorney is otherwise not in dispute. Next, what is the concept judgment?
On 165 there are two other judgments.
Yes,
I apologize because I was not able to arrange them
No.
like that. One is Shailesh. Actually, the first decision that I wanted to rely upon was by the Privy Council actually.
Which is that judgment?
That is NCB. Mary Mufani Jones and NCB National Toll Board.
Where is that?
That is part of the
Page number? Any sequence given? You have given the list.
Can you have you flag it for litigation?
Yes, please. हमारी intern अंशल गुप्ता कौन? अंशल गुप्ता is here? उनका इंटर्नशिप खत्म हो गया. Where is he? अभी अंशल पूरा हो गया. Yes, with judgment.
The last one that I flagged. The US Supreme Court. Sorry. In England.
Lord Denning, he is not there in US.
In England.
Is it arising out of India? Is it arising out?
No.
Then how do we know? Where is the corresponding provision of 157?
The National Poll Board matter.
What do you want to rely upon in this? Which provision of law is under interpretation?
165.
Where is it mentioned?
This was referred to by the Honorable Supreme Court in Shailesh, which is at number 4 of the marked.
Please read, Sanish.
Internal page 15 of that letter. That is where it starts. The reference to Jones is at page 60. The leadership may ignore NCB then. I'll straight away come to Shailesh.
So last one I can ignore.
Yes, because I am unable to show which is right. The principle of Jones was used in Shailesh.
Let us see the facts. What was the objection with regard to the manner in which the evidence
This is arising
was
out of a
taken?
criminal case.
That's right. Read para 11. Much reliance was placed on the recovery of two-wheeler, though it was not mentioned in the site plan. The delay in the recording of the statement of the witness was also taken into consideration,
Were also
taken lightly. The so-called dying declaration given by before PW1 was accepted despite a clear statement made by PW5 that none of them was present at the time of death. Correct?
Yes.
This was the nature of illegality which was being pointed out before the Honorable Supreme.
And thereafter,
Yes, where is the discussion?
yes. Internal page 15, para 29.
Para 29. Yes, please read it.
Section 165 of the Evidence Act speaks of the power of the court to put questions and order production of documents in the course of trial. This is a general and omnibus power given to the court when in search of the truth. Such a power is to be exercised against any witness before it, both in a civil as well as criminal case. The object is to discover adequate proof of a relevant fact, and therefore for that purpose the judge is authorized and empowered to ask any question of his choice. When such power is exercised by the court, there is no corresponding right that can be extended to a party to cross-examine any witness on an answer given in reply to a question put forth by it, except with its leave. Emphasizing upon the importance of Section 165 of the Evidence Act, Sir James Stephen, while presenting the report of the Select Committee at the time of passing of the Evidence Act, observed, it is absolutely necessary that the judge should not only hear what is put before him by others, but that he should ascertain by his own inquiries how the facts actually stand. In order to do this, it will frequently be necessary for him to go into matters which are not themselves relevant to the matters in issue, but may lead to something that is. And it is in order to arm judges with express authority to do this that Section 165, which has been so much objected to, has been framed. A judge or magistrate in India frequently has to perform duties which in England would be performed by police officer or attorneys. He has to sift out the truth for himself, as well as he can, and with little assistance of professional kind. Section 165 is intended to arm the judge with the most extensive power possible for the purpose of getting at the truth. The effect of this section is that in order to get to the bottom of the matter before the court, he will be able to look at and inquire into every fact whatever. Para 30.
What else?
Next page of it. Next.
What he has relied upon in your case are all admitted documents.
they are admitted and they have been produced. This is my case. I cannot exercise self-examination while because of being examined by the learned court under 165. So either the court invokes 165 or I get to examine myself. If the learned court exercises 165, then it cannot be in the manner in which it has been done in this case, because that is not a complete and proper use of that power. The complete and proper use is to completely adjudicate the case, is to turn out the truth, is to ensure that the truth is revealed. If there are adverse inferences being drawn based on documents that I have produced, which by virtue of that stand proved, at least so far as the existence of those documents, then in case there is apprehension or any sort of issue with the recital, the learned court should have put questions to me. I would have answered. Had I answered incorrectly, perhaps we would have had an even worse case before the learned court. But when the learned court does not put those questions to me, that opportunity is taken away. The judgment that I was relying upon by the England court, that has been cited in Jones versus National Court Board, just on the next page of that judgment.
Yes.
I wanted to rely on it because this sets the principle. In Jones, may I please?
Yes.
In Jones versus National Coal Board, 1957 to all ER 155, Lord Justice Denning observed, the judge's part in all this is to hearken to the evidence, only himself asking questions of witnesses when it is necessary to clear up any point that has been overlooked or left obscure, to see that the advocates behave themselves civilly and keep to the rules laid down by law, to exclude irrelevancies and discourage repetition, to make sure by wise intervention that he follows the points that the advocates are making and can assess their worth, and at the end to make up his mind where the truth lies. If he goes beyond this, he drops the mantle of the judge and assumes the role of an advocate, and the change does not become him well. We may go further than Lord Denning and say that it is the duty of a judge to discover the truth, and for that purpose he may ask any question in any form at any time of any witness or of the parties about any fact relevant or irrelevant, see section 165 Evidence Act. But this he must do without unduly trespassing upon the functions of the public prosecutor and defense counsel, without any hint of partisanship and without appearing to frighten or bully witnesses. He must take the prosecution and defense with him. The court, the prosecution and the defense must work as a team whose goal is justice, a team whose captain is the judge. The judge, like the conductor of a choir, must by force of personality induce his team to work in harmony, subdue the ruckus, encourage the timid, conspire with the young, flatter and old. Next, that is as far as 165 is concerned.
Just for 165, you have referred to
Ritesh and Shailesh.
165, you have referred to 2010, volume 10, SCC 677. Paragraph would be?
For Ritesh, para 37.
Para 37. Now you have this judgment. This is
Shailesh is para 29.
2024 Supreme SC 281. Para is
29, and then on the next page it is part of para 30.
para 29, 30.
Part of that.
Okay. Which judgment are you relying on?
With respect to putting questions to myself.
I don't know. Whatever. 165 is over, you need more.
165.
What else?
Now, in addition, I have Satpal. That is the second judgment.
Satpal is on which point?
That is the purpose of examining one's own witness. 145 read with 154.
145 read with
154.
154. This happens only when the witness is hostile.
This is what Satpal says, that there is no such thing as a hostile witness in Indian criminal jurisprudence, not contemplated in the Evidence Act. And it is steered clear deliberately, the legislature steered clear. This is what I wanted to show.
Para number
Paras 34, 38,
1976 1 ACC 727. This is stop writing. Para number
34,
34,
38,
38.
and 42.
Yes, read para 34.
From para 34. In the case of an unfavorable witness, the party calling him was allowed to contradict him by producing evidence alone, but the prohibition against cross-examination by means of leading questions or by contradicting him with his previous inconsistent statements or by asking questions with regard to his discreditable past conduct or previous conviction continued. But in the case of a hostile witness, the judge could permit his examination in chief to be conducted in the manner of cross-examination to the extent to which he considered necessary in the interest of justice. With the leave of the court, leading questions could be put to a hostile witness to test his memory and perception or his knowledge of the facts to which he was deposing. Even so, the party calling him could not question him about his bad antecedents or previous convictions, nor could he produce evidence to show that the veracity of the witness was doubtful. But the position as to whether a previous inconsistent statement could be proved against a hostile witness remained as murky as ever.
What do you want to suggest by this?
Yes, para 38 thereafter. This is the earlier position that is given in Satpal. What is now clarified in Satpal is at para 38 and 42. May I please? To steer clear of the controversy over the meaning of the terms hostile witness, adverse witness, unfavorable witness, which had given rise to considerable difficulty and conflict of opinion in England, the authors of the Indian Evidence Act 1872 seem to have advisedly avoided the use of any of those terms so that in India, the grant of permission to cross-examine his own witness by a party is not conditional on the witness being declared adverse or hostile. Whether it be the grant of permission under section 142 to put leading questions or the leave under section 154 to ask questions which might be put in cross-examination by the adverse party, the Indian Evidence Act leaves the matter entirely to the discretion of the court. See the observations of Sir Lawrence Jenkins in Vaikunthaj Nath versus Prasanna Moi. The discretion conferred by section 154 on the court is unqualified and untrammeled and is apart from any question of hostility. It is to be liberally exercised whenever the court, from the witness's demeanour, temper, attitude, bearing, or the tenor and tendency of his answers, or from a perusal of his previous inconsistent statement or otherwise, thinks that the grant of such permission is expedient to extract the truth and to do justice. To grant such permission does not amount to an adjudication by the court as to veracity of the witness. Therefore, in the order granting such permission, it is preferable to avoid the use of such expressions such as
See,
declared
this has got
hostile.
no relevance. It really has no relevance. Whom did you want it to cross-examine?
Myself,
The plaintiff wanted to cross-examine himself.
for example,
PW?
PW3.
PW3 wanted to cross-examine himself.
The para 42 is important.
Yes.
The fallacy underlying this view stems from the assumption that the only purpose of cross-examination of a witness is to discredit him. This is what I was getting at. It ignores the hard truth that another equally important object of cross-examination is to elicit admission of facts which would help build the case of the cross-examiner. When a party with the leave of the court confronts his witness with his previous inconsistent statement, he does so in the hope that the witness might revert to what he had stated previously. If the departure from the previous statement is not deliberate but is due to faulty memory or like cause, there is every possibility of the witness veering around to his former statement. With this, there is Bal Gangadhar Tilak. That is the second last judgment that I wrote. It is a judgment of the Privy Council. It's coming from Bombay. Take your ladyship to page 742 of that judgment. The page number is given in very small letters in the right under the first paragraph.
Page?
Page 742. This is both under section 33 as well as 145.
33 and
145.
140. It's 742. Yes.
From under section 33 of the Indian Evidence Act.
743.
742.
742. Yes. Under section 30.
Under section 33 of the Indian Evidence Act 1872, evidence given by a witness in a judicial proceeding in a criminal trial is relevant for the purpose of proving in subsequent proceeding the truth of the fact which it states, but this only as the section proceeds when the witness is dead or cannot be found or is incapable of giving evidence or is kept out to the etc. Not one of these circumstances was proved in the present case, and the deposition could not have been used with propriety even to support the evidence of the plaintiff, which they appear to have done. But there appears to have been no warrant whatsoever for using them for the purpose of either contradicting or discounting the evidence of the witnesses given in this suit, unless the particular matter or point has been placed before the witness as one for explanation in view of its discrepancy with the evidence then being tendered. It was stated to their lordships that the prosecution for perjury had in the end completely failed. With that, their lordships have nothing to do. The judgment now given is pronounced irrespective of the result of the criminal suit. Successful or unsuccessful, the introduction and use in this civil action of these criminal proceedings as above described were illegitimate. And there is another paragraph. Next paragraph after that. From but they must. But they must also record their dissent from the view that the use made of these documents in this case was justified by law. On general principles, it would appear to be sound that if a witness is under cross-examination on oath, he should be given the opportunity, if documents are to be used against him, to tender his explanation and to clear up the particular point of ambiguity or dispute. This is a general, salutary and intelligible rule, and where a witness's reputation and character are at stake, the duty of enforcing this rule would appear to be singularly clear. Fortunately, the law of India pronounces no uncertain sound upon the same matter. By section 145 of the Indian Evidence Act 1872, it is provided that a witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to the matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purposes of contradicting it. Their lordships have observed such and such. Thereafter, page 743. From not only have documents been used for the purpose of, from that point.
Sorry?
Page 743, next page. From not only have documents been used, it is latter half of the second paragraph.
I didn't get it.
Let's start from the beginning. Of the High Court. From of the High Court is an inferential verdict.
Of that.
So the latter part of that paragraph. Of the High Court is an inferential, nonetheless sweeping on that.
Not only have the documents.
Yes, not only this. Not only have documents been used for the purposes of contradicting witnesses without obeying the injunctions prescribed by law, but the inference thus derived and improperly derived from these documents has resulted, as stated, in an inferential verdict of perjury.
That's
That is with respect to 33 and 145.
it.
There is one short reference I want to make to Annapurna. That has already fallen from your leadership. So that is with respect to, since there is no disputed question of title, there is no occasion to go in.
Kolkata.
Sorry?
Kolkata.
Yes.
Place it, please.
It's 1922. That is the third judgment that I have. Para 7.
Yes.
If the matter is examined as one of principle, we cannot discover any substantial reason why a disputed question of a title should not be decided in the course of a suit for partition of joint properties, when we have not two sets of court with distinct jurisdictions like those exercised by courts of law and courts of equity. No doubt courts of equity is in assuming jurisdiction.
I'm not getting it. I read it, but I'm not getting it right now. It's at para number?
I'll just come to the.
It's para number?
Para number 7 onwards, I just want to come directly to the relevant part. Para 10 may be seen.
Para 10.
The essence of the matter. The essence of the matter is that the court, which is of general jurisdiction, administrating both legal and equitable remedies, may determine issue of title, investigate disputes between different parties claiming the same share, and then proceed with the partition so as to dispose of the whole controversy between them. So there has to be a claim. In truth, the limitation.
You read para 9. Apart from this.
Apart from this, whenever a court of equity determines that there are serious, yes, I understand what the limitation is. Apart from this, whenever a court of equity determines that there are serious disputes in regard to the legal title, it will not proceed until those doubts have been judicially determined and removed, and for this purpose will stay the suit for reasonable time with liberty to the plaintiff to bring such action as he might be advised to establish his title. None of it says that the court can go ahead and say that my title is disproved.
Para 7.
if the matter is examined as one of principle, we cannot discover any substantial reason why disputed questions of a title should not be decided in the course of a suit for partition of joint properties. When we have not two sets of courts with distinct jurisdiction like those exercised by courts of law and courts of equity, no doubt courts of equity in assuming jurisdiction on the subject matter of partition disclaim the authority to determine doubtful questions in regard to the legal title. A refined distinction
Yes, continue.
A refined distinction was sometimes made between a doubtful and a disputed title, and the question was raised whether the mere fact that the defendant disputed the title of the complainant was sufficient to oust the Court of Chancery of its jurisdiction. There are cases in the books where the broad proposition is asserted that whenever the title of the complainant is disputed or suspicious, equity will not proceed with the partition until the dispute has been settled at law. The view has not, however, always commended itself to the courts, which have sometimes drawn a distinction between a disputed and a suspicious title, and have maintained that a bare denial does not necessitate a reference to the legal tribunals. In other words, a court of equity, however, has jurisdiction to determine whether the title is free from suspicion and to prove and to proceed whenever in its judgment the title is clear. Lucas versus King, Overton versus Woolfolk. In the case last mentioned, it was emphasized that if a bare denial of the title authorizes the dismissal of the bill, the equitable jurisdiction is placed at the mercy of every profligate or unconscientious defendant and renders the court the mere ministerial agent to carry into effect the wishes of parties in cases where there were no matters of controversy between them. Apart from this, whenever a court of equity determines that there are serious disputes in regard to the legal title, it will not proceed until those doubts have been judicially determined and removed, and for this purpose will stay the suit for a reasonable time with liberty to the plaintiff to bring such action as he might be advised to establish his title. Gifford versus Williams. The same principle has been adopted where the defendants set up conflicting titles between themselves. While the title of the complainant was clear, Phelps versus Green, but where the courts which exercise jurisdiction over partition matters are entrusted with more ample power than a court of equity, no necessity exists for referring questions of title for trial by some other tribunal. This was pointed out by the Supreme Court of the United States in Parker versus Kane. Observe that it was not necessary to take the opinion of a court of law or to stay proceedings in partition suit until an action of law had been tried to determine the legal title where the powers of the court of law and court of equity were exercised by the same persons. If between the parties to the action for partition disputes exist as to their rights or interests in any respect, such disputes should be litigated and determined in such action. This view has been elaborated in later decisions, one of which, Baca versus Anaya, reviews the history of the law on the subject. See also Street versus Benner, Western, Stoddard, Griffith, obviously much force in the observation of Justice Pope in Baca versus Anaya.
Nothing else you want to say?
Only para 15 and 16 of the impugned judgment, where the learned court has said that it is disproved that act. That is para 15 and 16. Please. Considering the above detailed discussions and on the basis of materials available on record by way of pleadings, oral as well as documentary evidences, etc., this court came to definite conclusion that the plaintiff is not able to prove the facts stated in the sale deed Exhibit 1, which is the basis of the claim for partition and or title of the vendors. It is well settled principle that no one can transfer a better title than he himself has, and thus the plaintiff has also has not acquired any title on the suit land and consequently is not entitled to degree of partition as prayed for. Thus, point number 3 is decided accordingly against the plaintiff or say against both the parties. Being a suit for partition and the basis of title being the same document for both the parties as from material available before the court, it is disproved that the plaintiff and defendant have acquired valid title on the suit property by way of sale deed Exhibit 1 subject to partition. So when a suit is proceeding ex parte, The learned court has gone ahead and says that it is not only disproved against me, it is also disproved against the person who has not come before the learned court.
So this part anyways need not be sustained.
Don't think it can be sustained, this part particularly. And without it, the impugned judgment would not survive, because the reason leading up to this conclusion is 165 invocation. Either 165 or give me opportunity under 145 and 145. Because both cannot exist simultaneously.
That part I don't agree.
That is my contention.
Because basically the registered sale deeds were only taken.
The
into
problem is
consideration.
the
There
manner
was
in
no
which
evidence in terms of any oral evidence, and you yourself cannot dispute the registered deed, because those registered deeds are mentioned in your sale deed also.
But in order to be able to prove the veracity of those contents, I should have been given an opportunity. I appreciate.
No, prove the veracity means what? Anything which is mentioned in the sale deed is taken to be prima facie correct,
Yes.
right? 39 sale deed,
Yes.
that has a presumption in law.
I understand the aspects against me, I understand. The procedural illegality cannot be given, may not be ignored, because it is the only reason.
Procedural part is only to meet the justice.
But
to
when it
note.
causes prejudice and completely takes away my opportunity under 165.
And even if
whether it can be
whatever you
sustained.
had produced is taken into consideration, then it was not clear as to which portion of
Whether
the
I was
property.
entitled for a partition or not,
Yes.
that is where the learned court, with due respect, should have restricted itself, and I would have had a very difficult case. But here it has gone.
We will restrict it to that.
Maybe
First
remanded
appeal.
back also.
There is no question of any remand. Not a case for remand. Because we have to see every angle.
Because the learned
The
court has
power
said.
of attorney, the tempering in the sale deed, the rectification deed, everything has to be taken into consideration, at least on the face of it. The rectification does not rectify what you say.
Yes,
It
yes.
inserts something else.
Yes. And I cannot dispute it at this stage also. Because I have not filed an application under 4127.
This amounts to setting aside of your sale deed.
It amounts to cancellation of sale deed.
Cancellation
It
of sale.
amounts to disproving my title. It amounts to disproving of title of person who is not here. It amounts to making adverse influences on documents where I had no opportunity to substantiate. Only I agree that whatever I have produced, at least that much I cannot dispute that it says that. I cannot dispute that the contents are the contents that they are. But I must be given an opportunity under 165 to substantiate when it is the sole contention, I would say contention of the learned court, that those documents seem to be questionable at best.
By referring to the earlier sale deeds, the learned court has said what? That
Yes.
this was not the subject matter of.
It was not the subject. That is at running page 33.
Yes. All the sale deeds have been discussed.
Yes, actually 32 and 33.
So these sale deeds are not the subject matter. These sale deeds do not relate to the suit property.
No, they relate.
Then why is it that he has drawn adverse inference with respect to this sale deed? There is
Because-
some mismatch
Yes.
on account of some mismatch
Yes.
with regard to identity of property.
Yes.
So identity of
Gilhari Lal
property,
Agarwal, Gilhari Lal
identity of property, sir, could
Agarwal.
also
Not identity
be
of property, identity of owner.
identity of owner.
Because in my power of attorney, it is said Rameshwar Gawla and others. I will be fair. Had I been given an opportunity under 165, I would have explained what others means. That opportunity was not given. So now adverse inference is drawn because only Girdhari Lal Agarwal's name appears in that 39 and others. I don't know, I don't have the same deeds, the 1939, the 79. I was not the plaintiff who had adduced the same deeds in that suit. I was not given that opportunity same day it was done. So on that basis an adverse influence.
We have in the second half some other matter, right, which is likely to continue for quite some time. If it is over before 4 o'clock, then I will start the dictation of the judgment, record your preliminary whatever you have to, and then we can continue with the dictation in the courtroom. I hope you are staying back till 4:30. Court hours are over till 4:30, right? We'll try, otherwise it will be done tomorrow. But you have done a lot of work. That much I must say.
It can take only 1 minute to dispose of one person. Pass of one.
इसको जरा back करें. Dispose of in terms of compromise?
Yes, we have already paid the entire amount and he has withdrawn the execution case.
Oh, everything done?
Everything.
Everything has been done. And I have brought it on record. IA number 1422 of 2025 is the joint compromise.
FA number 176 of 2023, the learned counsel for the parties are present. This appeal has been filed against the judgment and decree dated 8/5/2023, within bracket decree signed on 12/5/2023, bracket close, passed by learned civil judge, within bracket senior division, bracket close Roman 2 Saraikela Kharsava, in original suit number 28 of 2019. Thereby, the suit was dismissed. Suit was decreed or dismissed?
Decreed.
Whereby the suit was decreed. The suit was filed for the following relief. Prayer quote कर देंगे?
Specifically.
हाँ.
Now
जो
joint
भी-
compromise is IA number.
Just was filed for the following relief. Quote करने की prayer में. The learned counsel for the parties have jointly submitted that a joint compromise petition
IA
number
1422
1422
of 2025.
of 2025 has been filed. उसके बाद एक supplementary affidavit क्या
वो
है?
दिन है वो जो comply किया उसका.
अच्छा, ठीक है.
For terms comply.
IA number 1322 of 2024 has been filed.
14.
134.
वो है वो
132.
स्टे का था.
अच्छा, वो स्टे का. Sorry. IA number 1422 of 25 has been filed. Putting on record the terms of compromise,
Yes.
which are as follows.
Yes.
It has been submitted by the learned counsel for the appellant that the terms of the compromise has also been satisfied, and for that purpose,
And complied with.
and complied with, and for that purpose, a supplementary affidavit has been filed on behalf of the
An
appellant.
execution case has been withdrawn by Annexer C. Annexer 2.
He has also submitted that the execution case has also been withdrawn. The
By the-
order of withdrawal of the execution case has been placed on record as contained in Annexure
2 to the
2
supplementary affidavit.
to the supplementary affidavit. The contents of the supplementary affidavit is as under. Quote कर देते हैं पूरा, ठीक है? Since the parties have the learned counsel jointly submit that the appeal be dismissed in terms of compromise.
Dispose
Oh,
of
sorry,
in terms
disposed of in terms of compromise. Okay. Accordingly, the appeal is disposed of in terms of the joint compromise.
बुजुर्ग के पार्ट से ही होगा. आई बहुत है दोनों एक दूसरे को.
देखिए, जब तक आप लोग नहीं चाहेंगे कोई केस कॉम्प्रोमाइज नहीं होगा. ये जो जितना जा रहा है मीडिएशन में, आप लोग के चाहे बिना थोड़ी हो जाएगा.
नहीं पार्टी के चाहे हम लोग पार्टी को राजी कराए, कॉम्प्रोमाइज कराए, पेमेंट भी करवा दिए, एवरीथिंग. तो बुजुर्ग इनिशिएट बुजुर्ग.
नहीं ऐसा नहीं, ऐसा हमको क्रेडिट मत दीजिए, आप लोग खुद ही क्रेडिट. वो जो ऑब्जर्वेशन होता है ना कोर्ट का, उससे थोड़ा सा खुश हो जाता है और कुछ नहीं.
जरूरी था. ऑलराइट.
आइटम नंबर 3 में ये फाइनल डिस्पोजल का रेडी है. सीनियर को करना था, बीमार है. तो अगर आज नहीं होना तो
आइटम नंबर 3 कौन सा?
फाइनल डिस्पोजल के बाद
फाइल
ऐसे तो हम इसमें रेडी हैं.
रेडी है तो वेट करिए. कोर्ट को प्रेशर थोड़ी डाल सकते कोई चीज के लिए.
राइजिंग आउट ऑफ लैंड एक्विजिशन.
क्या आपका केस है?
ये इनांसमेंट ऑफ कंपनसेशन का है.
क्या ग्राउंड है?
ग्राउंड है इसमें कि जो सेल रेट को कंसीडर किए हैं उसको सिर्फ इस ग्राउंड मतलब जो दिए हैं वो सर्कल रेट पे दिए, जबकि हमारा जो सेल रेट पे होना चाहिए. सेल रेट इसमें लिखा हुआ है लेकिन उसको कंसीडर नहीं करके वो सिर्फ सर्कल रेट. हम चार्ट आप बोले तो चार्ट बनाने के लिए चार्ट बना लेते हैं.
सर्कल रेट पे तो नहीं हो सकता.
नहीं
मार्केट वैल्यू पे होता है.
मार्केट में
सर्कल रेट कुछ भी हो, लोग कम पे भी, अगर मान लीजिए कम पे डीड है
हाँ
तो कम पे होगा।
हाँ तो कम पे होगा, उतना ही है, बस इतना ही क्वेश्चन।
कहाँ है अदर साइड?
स्टेट
रिकॉर्ड आ गया?
रिकॉर्ड आ गया।
जी
अगर आज नहीं होगा तो कल होगा, ठीक है।